We two work for a living.
No, but I would also imagine the technical team too, with other commitments.
I really appreciate the effort we wanted. All right. So we're beginning today in Part 7, National Firearms Registry, Section 88.
Chairman, may we defer the confirmation of the minutes? I think they need to be read, and I'm halfway through, and I know we will have to do some amendments ahead of confirmation.
So we'll defer the minutes until and start this confirmation. We deal with starting on Section 88. Minister, you want to lead us again, right?
Yes, Chairman. As you indicated, when the committee last sat, we got up to Clause 87, and we're to resume at Part 7, beginning at Clause 88, the National Firearms Register. Ms. Grant?
88, National Firearms Register. 1. The Director of the Institute shall, as soon as practicable after the earliest appointed day under Section 1, establish, maintain, and operate in accordance with this Act for and on behalf of the Government of Jamaica, a data bank to be known as the National Firearms Register. 2. The purposes of the register shall be for A. The storage and retrieval of information relating to firearms and ammunition, including information relating to firearm authorizations. B. Assisting with criminal and other investigations in the administration of justice. C. Compiling statistics relating to firearms and ammunition, including data on firearm ownership. D. Providing information to aid decision-making in the interest of national security and public safety in matters relating to firearms and ammunition. E. Providing information relating to research on firearms and ammunition. F, any other purpose specified by the Minister by order. 3. The register shall include information in relation to A. Import and export permits. B. Transit permits and transshipment permits. C. Export authorizations and import authorizations of conventional arms. D. All categories of firearms and ammunition. E. The ballistic profile of firearms. F. The physical parameters to be determined by the firearm and tool mark examiners, including 1. Tool mark information, and 2. Any other information on firearms. G. Ammunition profiles, and H. Any other information prescribed under the Fingerprints Act, the Dangerous Drugs Act, the Evidence Act, the DNA Evidence Act, or the Evidence Special Measures Act. 4. The Minister may, by order published in the Gazette, A. Amend the categories of information referred to in subsection 3, and B. Require other entities to maintain any information referred to in subsection 3. 5. For the purposes of this section, the relevant authority shall cause to be transmitted to the registrar the information required under this section in relation to firearms authorizations granted by that relevant authority under this Act.
Just a pause. In respect of 2D, the intention is that all firearms, wherever they are, whatever the type, whatever the category, would be contained in the register, or those in respect of those that are on the island?
It would be those that are on the island.
Right. So I think we may have to put some qualifying wording. All categories of firearm and ammunition. The register shall include information in relation to all categories of firearm and ammunition.
Can I ask a question? How is it presently stored? Like when you, they have the ballistic markings and so on, they keep a record of it?
No, be stored at the Forensic Institute. Right, that's where it would be. Currently, I think most of the data is split between the Firearms Authority, FLA, and Forensic Institute. Forensic Institute for those that are involved in activity, but the register of the firearm law will now be established at the Forensic Institute.
If one needs any information for court, they would now go to the registry instead?
The registry, yeah. Which is essentially be part of the forensic ballistic center up there, which is being built out. Well, they have the adequate hardware to carry the data and protection and all of that, so it's a good place for it.
Is that the register? How is the register assist with criminal investigation, criminal and other investigation in the administration of justice? Purpose of the register shall be for assisting. I mean, that is through the provision of relevant information. So we may need to look at the wording there at B also. Yes. 2B. Right, can proceed. So we note 88, 2, B and D to consider whether qualifying words should be added.
What was concerning to me why I asked the chairman that question. How, the how and so on.
Yes. So it's containing the import and the export permits, but not, and the transit permits and the transshipment permit. So the register doesn't also contain the authorizations that are granted, all the types of authorization?
That's covered in 2A.
Thanks. We can proceed.
89, functions of registrar. 1, for the purposes of this Act, the director of the institute shall carry out the functions of the registrar. 2, the registrar shall, in accordance with this Act, carry out the following functions. A, receive, store, and retrieve information related to firearms and ammunition. B, keep, maintain, and operate the register. C, establish and maintain policies and procedures for the sound management of the register. D, ensure the security, integrity, and confidentiality of the register. And E, perform such other functions pertaining to the administration of this Act as may be assigned to the registrar from time to time by the minister. 3, in exercise of the functions conferred under subsection 2, the registrar shall A, take appropriate steps to store and maintain information in the register. B, cause searches of the register to be carried out. C, put in place methods of electronic storage that accurately record firearm information and facilitate easy retrieval of such information. And D, prepare a report on any analysis requested by 1, the authority, 2, a court, 3, a law enforcement agency, or 4, the central authority, being a request that has been approved in accordance with the Mutual Assistance Criminal Matters Act, and disclose the report to the requesting entity. 4, the registrar shall ensure that in the exercise of the functions conferred under subsection 2, all preparation and disclosure of information pursuant to analysis made under subsection 3 are conducted in a manner that secures against A, disclosure or use of information in the register in a manner contrary to this Act, any other law, and any international obligation or commitment, and B, the compromising or obstruction of any investigation in relation to an offense under this Act or any other law. 5, in this section, law enforcement agency means a person or agency having investigative or prosecutorial functions under the laws of Jamaica in relation to criminal offenses. Part 8, power of search, seizure, and to obtain information. 90, power to stop and search conveyance. 1, any constable who reasonably suspects that any firearm or ammunition is aboard a conveyance may, without warrant, A, stop the conveyance, B, search the conveyance, the operator thereof, and any other person in the conveyance. 2, where pursuant to subsection 1, a constable requests that a conveyance stop, a person commits an offense who, A, being the operator of the conveyance, fails to stop the conveyance when requested to do so by a constable, B, being aboard the conveyance, prevents or intimidates the operator thereof from stopping as requested by a constable, or C, escapes or attempts to escape from the conveyance. 91, search warrants. 1, a justice of the peace, on being satisfied by information on oath that there are reasonable grounds for suspecting that an offense under this Act has been, is being, or is about to be committed, may grant a search warrant authorizing any constable named therein, A, to enter at any time any premises, place, or receptacle named in the warrant, including by reasonable force if necessary, and to search the premises, place, or receptacle, and every person found therein. B, to seize any firearm or ammunition which the constable finds on the premises, or in the place or receptacle, or any such person, or on any such person, in respect of which, or in connection with which, the constable has reasonable grounds for suspecting that an offense under this Act has been, is being, or is about to be committed, and C, to retain the firearm or ammunition for so long as may be necessary for the purpose of any investigation in relation to the offense, and where such investigation results in legal proceedings against any person for the offense, until such legal proceedings are finally disposed of. 2, the constable making the search may arrest without warrant any person found in or on the premises, place, or receptacle whom the constable has reason to believe has committed an offense under this Act, other than offense under Section 74, breach of duty to safely store firearm and ammunition. 92, power to search and seize conveyance or premises. 1, if any constable, officer of the Jamaica Defense Force acting in furtherance of the Maritime Areas Act, or officer of the Major Organized Crime and Anti-Corruption Agency, in the lawful execution of his duties, has reasonable cause to suspect that any conveyance or premises is being used or has been used in the commission of any offense under this Act, then that constable or officer, as the case may be, A, may, without warrant, search the conveyance or premises, and B, if the search reveals evidence that the conveyance or any item or premises searched under paragraph A is being used or has been used for the commission of any offense, shall seize the conveyance or item, as the case may be, and retain it for so long as may be necessary for the purpose of any investigation in relation to the offense, and where such investigation results in legal proceedings against any person for the offense, until such legal proceedings are finally disposed of.
Chairman, I had a question in relation to, we've long past it, but I've been a little concerned about it. And that is where there's the section that requires that the registrar shall ensure that the matters are conducted in a manner that secures against disclosure or use of the information in the registry in a manner contrary to the Act, and so on, or the compromising or obstruction of any investigation in relation to an offense under this Act or any law. So this is an additional duty But where we have these kinds of duties, there tends to be some sanction for failure to abide by the terms. I'm sorry, 89.4. And I want to understand what the policy is around this, why there shouldn't be a level of sanction if this is not adhered to, because it's a really, really serious breach, 89.4. It's a really serious breach, in my view, to disclose or use contrary to the intention of the Act. So I just wanted to ask the Minister if there was a particular reason why this was omitted.
Richards.
Minister, remember, we actually did consider it, but we thought it was something that could be managed administratively in terms of the terms of employment or contract of the person who is the registrar at the time, as opposed to criminalizing the offense.
Why not? If this is the nature of the breach. I mean, I'm trying to reflect on what the Data Protection Act said, for example, or NIDS said. And if you use this information here, which is very important and sensitive national security information, if you use it contrary to the legislation, shouldn't you have a sanction?
Sorry.
Why?
There is provision at Section 104 providing for confidentiality of persons having an official duty under the Act, and breach of that is an offense. Section 104, it's at page 78 and 79.
It's a matter for the technical team to see if that is adequately addresses the concern.
I think 104 addresses the issue. Satisfactory? Or we need to?
Could I just follow on with a question on that, Chair? Senator Scott Motley, I think, is asking in relation to a sanction against the person who discloses or causes the disclosure being an employee being the registrar or an employee of the authority. Or my question is there any remedy in this Act for the person aggrieved by that disclosure, or is that simply a remedy they must find in civil court, or has anything addressed that?
There's no remedy prescribed in the legislation for that. Yeah.
But may I just ask, if I'm not sure if Senator Motley is satisfied with the response in respect of 104 for the breach of confidentiality. I think your concern was mainly in relation to the maintenance, or was it in relation to the disclosure of the information?
The breach is quite significant. And the penalty is quite significant. $1 million are.
Sorry, Mr. Bailey, you are speaking to me? I was actually looking at another section. Yes, could you repeat it?
I was asking if you were satisfied with the response in respect of the breach of confidentiality, because my interpretation of your comment was in relation to the maintenance of the database as opposed to the disclosure of the information.
It was broader than the disclosure of the information, definitely. For example, it goes on to say it has to be conducted in a manner that secures against the compromising or obstruction of any investigation in relation to an offense under this act or any other law. Mr. Richards, so I don't think secrecy and confidentiality would meet the concerns which are raised in this section. This would be a really egregious act, and in my view, should have some criminal sanctions.
In other words, Senator, may I understand what the Senator is saying, that there should be a criminal sanction coming at the end of 4 relating to the entire conduct of the registrar in relation to 4. Because
That's what I was saying,
yeah,
Chairman.
because the breach of confidentiality is clear, but their conduct in relation to, say, for example, an investigation, compromising or obstruction of investigation, in other words, wouldn't be covered by confidentiality. Or what's the... I can see why it was accepted in the original form, but this is a relevance, because if the person, for example, withhold information from an investigator, part withholding, it wouldn't be, it's not confidentiality, but it would be a significant breach that could change the course of a trial.
They could have a look at it and give us their views as to, just make a note so we can look back at it.
Some of the matters are dealt with in the Data Protection Act. I was just checking back because we did consider the provision at the time and felt that it was provided for in law in respect of any improper disclosure. Right. Disclosure or use, yes.
So, just to respond to that also, the provision in 89 is really imposing a duty on the registrar to ensure that certain things are in place. So 104 deals with the staff generally, and if you look at 104.3, it prohibits disclosure except as permitted by the registrar, among other things. So it's really directing a channel through the registrar, which would determine how disclosures are made.
If I understood the concern, is that what if the registrar becomes errant or the registrar does not exercise the due care and attention that is required? How do you deal with that exercise? But we know that if the registrar breaches the duty that is imposed, then there is in fact the remedy, of negligence. In negligence.
And just to answer Member Campbell's question about the compensation, there was an amendment made to the Criminal Justice Administration Act in 2080 that provided a general procedure for restitution to be made, restitution orders to be made when a court is imposing any sentence in respect of a criminal offense.
That was under the victims' rights, moving the jurisdiction in that direction of ensure. Well, a crime where someone is charged with a crime, it's not meant to be addressed in the same way that civil wrongs are done, because a crime is viewed as a wrong done to all of the realm, all of the society, not just limited to the offender and the immediate victim, but giving the court the discretion in an appropriate case, depending on the evidence that is before it, to make a determination. At least that is now provided for in our law. Always important that we have in the forefront of our mind basic principles of law and the distinction between the criminal law and the civil law.
All right. Make note.
93, power of constable or authorized officer to require production of firearm authorization. 1, a constable or authorized officer who sees any person carrying any firearm or ammunition in any public place may require that person to produce to the constable for inspection A, the person's firearm authorization in respect of the firearm or ammunition as the case may be, and B, If such place is within any security restricted area, the person's firearm uses special permit in respect of the firearm or ammunition. 2, where a person required under subsection 1 to produce a firearm authorization falls within an exception under section 46(1), exceptions to restriction on possession of firearm, ammunition, etc., the person shall provide satisfactory evidence of the exemption. 3, a person who fails to comply in accordance with subsection 1 or 2 with a requirement made to that person under subsection 1 commits an offense.
Just a pause, Chairman, do recall or post-bill discussion that we will have to look back at how we deal with persons who do not have their authorization on their person. So although the law imposes an obligation to carry the authorization, the purpose of that is to ensure that you can identify and identify the person and then trace back the firearm. But with the establishment of the register and other things in the law, that process over time will become less difficult. And so we may have to provide a time window, except for the special permit for the restricted area, which is for a particular purpose, to provide a small window where persons can then present their authorization, so as not to unduly criminalize someone who would have gone through the process, been deep vetted and authorized to possess the firearm. Because we have to look at the entire scheme of the law and see how we have closed out the gaps and the systems that are going to be put in place. So we're certainly not going to be in the same place that we were some years ago of not being able to identify persons and link a firearm to someone, because a register, you'd have to go, the duty to submit it, the inclusion of it in the database, all of that kind of information can be retrieved with ease over time. So just to I think, no, not at all. A 24-hour window is what.
Next day.
I'm sorry?
24.
Yes, next day. Because you can remember the system is being automated across numerous areas. It's one of the matters we discussed.
I'm with you.
It's one of the matters we discussed.
But just it's a little bit wary of persons who have no ID. They need some certification when they're traveling.
No, not the person who has no ID. The person who does not have the authorization on them at the time. No, not the ID.
When you give him, and it certainly should have the payment certificate. Well, how do you produce the firearm? What's basis for releasing him if you have no authorization?
So the reprieve contemplated a situation where someone is duly authorized, brings a firearm.
Yeah, but he has nothing to say he is.
I'm sorry?
He has nothing to show that he is authorized.
No, let us say, well, Chairman, recall the.
I'm a discussion between the authorization and the certificate
of
payment.
But we do have provisions in other law, under the Road Traffic Act, for example, where you can provide. The firearm would have markings on it so that an officer who.
Yes, that's where we've gotten. But how do they check that the markings? Because that's not yet in place.
Right, in time, I'm saying. Remember the law.
Right.
You are required to register your firearm. I can't remember exactly which section it is. It's registered with all the data. I give you my name. You go in the system. You're supposed to be able to bring up the relevant information. So I don't see any harm that would be done.
I certainly agree with that. I don't think we should criminalize the licensed firearm holder for not having his...
And I have, this morning I left home and I left my wallet with my ID and all my cards.
I'm just trying to work
very
out.
sympathetic this morning.
No, I'm with you, and with the committee, I'm trying to work out how the practicality of it, right? Because
we have provisions in law that can deal with it.
In other words,
the CPC.
the most recent case, the gentleman has a licensed firearm. He's actually transporting, but he's transporting a legal firearm. He has a firearm license. So you have to, well, and we are not criminalizing the person for not having his firearm license, but they just want to work out the practical application, right?
So, Chairman, we always have to go back to the policy. So the policy of this law is to make a sharp distinction between persons who are duly authorized
and those who are not
hold firearm after going through a deeper vetting process. The policy behind the law is also to establish a database, a system of registration, a duty to turn in the firearm to ensure that it is marked and that information is put in a database. Then you are empowering a constable who sees someone carrying a firearm or ammunition in a public place to produce to the constable for inspection the authorization or the special permit. And if they fail to produce it, they commit an offense. All right, so...
Pause a little bit, Minister, because I'm with you there that
yes.
That should not be an offense until it is proven. So the 24 provide. What I'm looking at is the practical side of it. If is a stranger, total stranger police officer, produce a firearm, is duly licensed, but the officer has he doesn't know the gentleman, which is in the law, he shouldn't have to know him, and he doesn't know the firearm, and he doesn't have access to registry immediately. Which will take a little while as we get.
I would imagine, Chairman, that the constable who happens upon such a person would do what is necessary to satisfy himself that the person is not committing an offense. And so if you have to detain briefly, you will detain and make the necessary inquiries. My point was in respect of the offense of not producing it, and to make something in the law so that the prosecution, perhaps, we had provided for it in another of the clauses as to the prosecution shall not commence within a certain time frame. It's just that provision I'm saying, but I would certainly expect a trained officer who comes upon someone who says that I do have an authorization, it's just that it's not on me, as part of their training to detect and prevent crime, to do what is required to be satisfied that this person is not breaking the law to the point where they are to be prosecuted.
No, we're at one, because I said
yes.
the idea of separating the illegal to legal firearms is not to make it so burdensome and those who have gone through the process legitimately, but also make it practical as well.
Right.
That's
so,
what the matter I'm looking at.
Right, and we are agreed on that. All persons authorized to carry firearms will have to understand, as many do, the burdens that are placed on them.
Ultimately, the idea is, at worst, he should be able to call control center and get a report within a few minutes. So the inconvenience of not carrying a license would prevent him from, would ensure still that there's a burden to carry a firearm license, but if he loses it, it may cost him half an hour, which is all it should cost to get access to the database. In other words, I call control center, just like a driver's license. Make sure it works. Yeah.
Just to summarize, in respect of 3, is to add the provision just to allow the small window for the authorization to be produced before the offense, the prosecution of the offense takes place. That is what we had agreed in policy. Yes.
Just to add, we were considering whether we should also include a provision to allow the constable to seize the firearm until the authorization is verified or produced.
I would support that suggestion, Chairman.
Yes,
I would.
it stands to yes, because
yeah.
you
have to go through a process. It's like seizing the vehicle.
It would be more securing than seizing, in a sense. You're securing the firearm as opposed to seizing the firearm.
Retain it. Yeah. Retain as opposed to detain.
Yeah. No.
I mean, as opposed to the action that would give rise to
I don't, as
a cause of action in detenue.
We shouldn't criminalize regulation like that, but we have to find a way to be practical. No, yeah.
Draw the distinction, even though some may say it is splitting here, of holding on to it as opposed to seizing it, because an unlawful seizure does have a remedy in tort, right? So,
I say for legal
but yes, but
safekeeping until.
But it is carrying through the policy of ensuring that for persons who are properly authorized in the event of an omission with no criminal intent, that we do not bring down the criminal law on them. When the law comes down on them, it's going to come down on them heavily. So, provision to be included after.
As the philosophy, the whole policy behind the law,
94.3.
avoid criminalizing too much of the
Yes.
breach of regulations where the person is authorized, so that you come on hard on the legal person. So as we go through, we look at those and.
My view, Chairman, is that the laws must be fair. Persons must be educated on what it is. And thereafter, if you act outside of the law, you do so to your peril, knowing that, especially in the area of firearm, that the consequences will be dire, because we can't continue with what we have. So, for the record, it would be to add a provision which would permit the constable to retain the firearm until the authorization is produced, and to give a small window of time for the production before the offense of failing to comply with the direction to produce the authorization is prosecuted. Right?
'94. Powers of constable in respect of concealed firearm. 1. Where a constable has any reasonable cause to suspect that a person is carrying any firearm or ammunition concealed about their person, the constable may A. Ask the person if the person is carrying a firearm or ammunition. B. If the person admits to carrying a firearm or ammunition, require the person to produce 1. The firearm or ammunition, 2. The person's firearm authorization in respect thereof, and 3. If the place in which that person is carrying the firearm or ammunition is a security restricted area, the person's firearm user's special permit in relation to the firearm or ammunition. 2. Where a person required under subsection 1B2 to produce a firearm authorization falls within an exception under section 46(1), exceptions to restriction on possession of firearm, ammunition, etc., the person shall provide satisfactory evidence of the exemption. 3. Where a person fails to comply with a requirement made by a constable to that person under subsection 1, or denies that the person is carrying a firearm concealed about their person, the constable may A. Without a warrant, search that person and seize and retain any firearm or ammunition carried by that person until such time as legal proceedings against that person in respect of any offense in relation to the firearm or ammunition are finally disposed of, and B. Require that the person declare to the constable immediately the person's name and address. 4. Where a person refuses to comply with a requirement made to that person by a constable under subsection 1 or 3B, or fails to give the person's true name and address, the person commits an offense and the constable may arrest the person without warrant. 95. Retention of firearms and ammunition. 1. Where a person is arrested for an offense under this act, any firearm or ammunition found upon that person at the time of the arrest or at the time of the person's alleged commission of the offense shall be retained by the police until such time as the person is released or legal proceedings against the person in respect of such contravention are finally disposed of.
This provision can be retweaked, so it's not only upon the arrest itself, but where the inquiries are being made, where the person is detained or arrested. Not I think, detained or arrested. Yes, it would deal with that part of it, but we'd have to just reword it. Yes. And you note this is a retention as opposed to a seizure. All right. Yes, I do.
2, a constable who takes possession of any firearm or ammunition pursuant to any power under this Act in relation to the commission or prevention of an offense may retain such firearms or ammunition for so long as may be necessary for the purpose of any investigation in relation thereto, and where such investigation results in legal proceedings against any person for any such offense until such legal proceedings are finally disposed of. 3.
No concerns would be raised about how long is so long, and to ensure that firearms are not just taken and retained without investigations being done in a timely manner. Well, you know, Chairman, like I say, citizens have been aggrieved in so many ways by the lack of timeliness. Yes.
What I'm trying to figure is how do I structure this in law? I mean, the law is, who is the prosecuting lawyer here, though?
Well, there will
the judge.
have to be a time frame within which persons are notified of the progress that is being made, what you're investigating them for. And this is something that, we have to take a strong view that anyone who is exercising a public function on behalf of the state has to understand that the functions have to be discharged in a timely way.
Yeah, I think, given that this also applies primarily to firearms with authorization, there should be some frame. If a legal firearm is seized anyway, permanently, for authorized, if you take a man for a licensed firearm, you should give some time frame in which you return it. How do you show?
So, Chairman,
draft.
Bear in mind again that this matter is being done in a particular context, because the identity of persons, including their fingerprinting, etc., those matters, those bits of information are taken, and there is, well, it depends. There is a time frame within which certain preliminary but foundational matters can be ascertained. It doesn't specify the type of offense, and it may take time sometimes to investigate, but certainly with a system, when it becomes fully in place, you should be able, even if the person does not produce the information as part of investigation, you should be able to identify the person through any of their biometric information, and you should be able to ascertain whether an authorization has been given, and you should be able to trace the weapon in question. And if you can't do that, then they would be falling on the other side of the Act. Because over time, all persons who are authorized and all firearms that are lawfully traded would be in the database.
Yeah, Minister, I'm agreeing with how some puts it. Okay? Once the registry is established, the officer who have retained the firearm can identify the individual and the registration and all are settled. So unless he has reason, he must have some reason to retain the firearm beyond if this person has been through. If there's a charge, what kind of time frame do you allow? He has to lay a charge if he's going to retain the firearm.
Pointing it out, in any event, if you are going to charge someone, the firearm would be an exhibit, and you usually retain exhibits.
Sometimes the charge should be laid in a certain time. If bail out now, which we have disputes on the time frame, what the bail says, 48 hours?
It's only because it doesn't qualify. It says an offense under the Act, any power under the Act, in relation to the commission or prevention of offense. So if, for example, it is the offense of failing to produce, because at the end of the day, what are you seeking to do? You're seeking to ensure that the person in whose possession the weapon is found, that the person authorized appropriately. So I think for me, it's an offense without any accepting of it, because not every offense would require for so long as. I mean, yes, so long as it may be necessary.
Minister, let me see if I understand what the chairman is saying. So, chairman, the mischief you are trying to cure is the likelihood of the firearm being retained in perpetuity.
It's very long. In other words,
yeah.
If the way it's just, well, from the layman's point of reading this, you can say, look, I'm investigating you for X or Y. You can keep the firearm. The investigation can proceed with it indefinitely based on this here. And then there has to be some, where they have to have some confidence in the investigating officer, there need to be some, so that's it.
Well, I guess what we could do is look at a provision that could allow the person to seek a review from the court, judging chamber, wherever, in respect of that.
I'm really just signaling that because the provision is worded to cover any of the powers exercised and any of the offense. Remember that not all offenses are created equal under the law, and it is expected that a certain level of reasonableness would attend on the exercise of the power under the law.
If you think it's too broad, Minister, suppose you separate. There are two offenses on the Act. There's breach of the regulations on the FLA, and there is criminal action that you're investigating.
Yeah, because I totally understand what the minister is saying in respect of the reasonableness, etc. But we and I looking at it from a practical point of view, where reasonableness does not necessarily apply in all cases. So I can see where the mischief lies in terms of the likelihood of indefinite detention, retention, or
It can be dealt with, I'm raising it just for a discussion of it, not necessarily that it has to be changed, because what is reasonable, the courts have pronounced on it, will depend on the context and the circumstances of a particular case, and no doubt it would assess which power was exercised in relation to which offense and all of the circumstances, and what may be adjudged reasonable in one case may be entirely unreasonable in another case, and vice versa. All right, we can proceed.
95.3, where legal proceedings have been instituted against a person in respect of an offense mentioned in subsection 2, and the person is A, convicted, section 96, forfeiture of firearms and ammunition shall apply, or B, acquitted, and it is proved that the person is the lawful owner of any firearms or ammunition seized in relation to the offense. The firearms or ammunition, as the case may be, shall be returned to the person. 4.
The more I think about it, is the more we may have to probably rethink some of the offense, how we word some of the offenses, and whether we may want to provide for reasonable excuse. For example, if the person is given the time to produce the firearm, authorization doesn't do so, you decide to prosecute. But as it turns out, it is a firearm that came into the system, is duly put in the database, etc. The forfeiture of it, may not be what the policy intends. It may have other consequences. But what we have now is the strict liability on the part of the authorizee to comply. And I think, Chairman, we may, in light of the policy discussions we've had, we may just have to look back on it. It doesn't mean that there is no duty, but it may have to provide for a reasonable excuse once the firearm is actually lawfully traded and dealt with.
Chairman, I just wanted to echo, I have gotten a lot of feedback about that particular point that Minister has just raised. So I also echo her sentiments and would support very much a request to the team to take a look back at that strict liability versus reasonable excuse regime. And the other thing that may fall in that same consideration, when you're looking at the offenses, it's a question of the mandatory minimum sentences, and how that will play once you make that change.
Have the mandatory minimum on the side where the firearm is lawfully traded and the holder or the person in possession has been authorized after the deep vetting process. It's on the other side, but there are strong penalties still on the side. But the policy, and that's why it's so important to, once the policy goals are clear, we have to ensure that whatever else flows, that they are consistent with the policy. And broadly speaking, the policy on the regulation side, where the firearm has been lawfully traded and enters the country lawfully and someone is authorized, is not to have the same kind of consequences, even though duties are placed and obligations are placed on the licensee.
We can go on out to 96, make note of the comment to 95.
95.4.
95.4, yeah.
Where no legal proceedings have been instituted against a person in respect of any offense mentioned in subsection 2, the firearms or ammunition, as the case may be, shall be returned to the person who is proved to be the lawful owner thereof, or if no lawful owner is proved, shall be transferred to the authority for disposal in accordance with section 102. 96.
Senator.
In a case where no legal proceedings have been instituted, could we put some time frame within which the firearm must be returned? Otherwise, this subjects the firearm holder to...
It's the same. That's what we have been discussing along this.
You had made it before I came?
Part of it, yeah.
Okay.
I'm trying to come to some...
well, my apologies, but I'm just
the
one we're on.
We are interrogating the issue thoroughly because it's the practical side we're trying to show can do it practically. That nobody is seized and locked away indefinitely by any officer. So we are in the same tune, it's just to get it in.
Okay, so it is proposed to put up some finite period within which the firearm should be returned.
Well, I don't think we had to set a finite, but I think there was a qualification. Minister had made a suggestion.
Also have to look at what is provided for at 95.4, because it really is going to be returned if the lawful holder was not complicit or negligent or aided and abetted someone else to come in possession of the firearm. So while the policy is to return it, it could be a case where it is stolen and so it needs to go back. But it could also be a case where the person who is authorized probably turn a blind eye and enable it. And in those circumstances, the policy is not for it to be returned to such a person without more. So this 4 will also have to be looked at against the policy.
I think involves their own.
Yes.
Two ministers say it's once the firearm is retained and the authorized owner is identified, then there should be some time frame in which either charges are laid or it is returned to the person. I think that's really what it's, from a layman's point I'm seeing here. Am I right here that if there's no charge against, no charge or complicity on the part of the authorized owner, he get back his firearm within a reasonable time. But what's that reasonable time?
I think it's quite a proper request that if no proceedings are instituted, that we could look at a time frame, because you also do not want the FLA or the Institute to be having matters prolonged, right? If you have reason to believe that an offense has been committed, it is to be investigated soonest. Remember, this is the area that challenges us the greatest on the crime front.
If I may, I go back, I just say it lightly, it might work a while. Your bail act says that a person is held, they have to be released within a certain time frame. What is it? 48, 5, unless there is reason. You have to treat the firearm the same way. If
The deciding point would be after a decision has been taken, because it is very difficult in the Jamaican context to determine how long an investigation is going to last when you have unwilling persons. But once you have made a decision one way or the other, taking the decision should act, if we speak analogously, it crystallizes something, and then strict time limits should run after that.
That's a question, Chairman. All right. If you detain someone, right, for minor breach, whatever it is, but you're going to investigate him, but you have to, the time frame given to give bail would be similar. If you take the man firearm, you identify him, because let's say lack of value, he didn't have his authorization. You find out it's his firearm, he's authorized to carry it, he has been through the due diligence. That shouldn't take more than 48 hours, literally, or 2 working days.
72 hours.
I said 2 working days, so it can be Friday and Monday. Unless there is good reason to retain him after that, he should be able to get back his firearm.
Chairman and Minister, you could just assist. The term legal proceedings, would that include the period of investigation prior to being charged?
That was not the intention. The intention was the institution of proceedings before the court. So the reality of the situation is that investigations may take time. What you want to ensure is that proper progress is being made, and that an investigating officer isn't just going to say, well, I get the firearm, so that's the end of it. It's like, arrest the man, he's no longer out in the public, so I can just cool off, kind of thing.
Let me ask.
And if persons are released while investigations are ongoing, no, you can't give him his gun in those circumstances, because you don't know whether the investigation would lead to a charge. Because what you would be safeguarding is his liberty in those circumstances and not detaining him, because a police officer may properly detain someone in accordance with the law, but you may release the person, grant him bail, put him under recognizance, whatever, and you continue the investigation. If the firearm is implicated, it certainly couldn't be proper to have the firearm returned to him in those circumstances.
No, but
what I'm asking again is, all right, I can understand. If there is no, it depends, the investigation is toward laying charges. So there has to be a reasonable level of, what is it, a law of suspicion. In other words, if find out that you do a checkpoint is established, car is searched, the driver has a firearm, he has no license. So we can retain the firearm, check that he is a legitimate owner. Now, that's the first step. To retain the firearm beyond that period would have to have good reason. There has to be investigation. So
depends on what. So you may establish that the firearm is properly registered. You may determine that the person is authorized, but you can still have offenses being committed in those circumstances.
So I'm saying there should be some level of, can the law not recognize that if there is no reason to pursue an investigation, then he's released. The firearm is released, and if there's an investigation to a particular case, ballistics should be identified within a reasonable time as well, to see if that firearm was involved in a criminal act.
Right. But Chairman, it's not every minutia that we legislate, because the law does set standards around the exercise of functions, and in particular statutory functions, and that's why persons can go before the court. We're not in the habit of legislating administrative acts. I mean, sometimes that is done in regulations, but generally we don't legislate administrative acts, because the courts have pronounced on matters of this nature.
Mr. Chairman, let me put a scenario. Under 95(2), a constable approaches a licensed firearm holder and say, I have reason to believe I have reason to believe that you discharged your firearm at a party last night, and I'm taking possession of your firearm and ammunition while I investigate. The person denied, no, that was not me, I was not at the party, but I am seizing the firearm and ammunition until I investigate. Now, you're really giving that constable power to hold on to that indefinite, because I say, boy, actually I'm very busy, and I haven't had a chance. Now, if the only recourse that holder has is to seek some judicial review.
No, we agree that should be modified.
You're putting an unreasonable burden on that person.
No, we agree that section ought to be dealt with. What I'm looking at is the next, if there's something else behind that, is how do you recognize that? We agree that if you take a licensed firearm holder, retain it once it is proven that it is his firearm, and there's no indication, you can't just say fire the firearm at a party last night. There has to be some basis for that, right?
And it can't just be the minister's favorite reason to believe. The reason maybe somebody heard a firearm discharge and saw it coming from the direction where that person was standing.
Member Bunting, reason to believe is the antithesis of arbitrariness. Reason, I think you may be confusing reason with mere information. Reason is at a higher level. And above everything else, you have to have some reason. So it may be that somebody heard explosions, which sounded like firearm, that the person who is suspected was present and had a firearm. It may be that someone who was there reported to the officer that they saw the person, among a number of things. Those are the bits of information that would cause reason. So without more, when information gets to a police officer, the officer is expected and is trained, notwithstanding behavior to the contrary, to assess whether you probe it further or not. And every information received is to be probed and a decision taken. How much further do I go? Do I dismiss it? I think part
Which is
of the
all
problem...
I'm saying is let us put a finite period on that investigation. So either that reason to believe translates to evidence sufficient to charge the person.
You're beginning to make me wonder what your experience has been in the Office of Minister of National Security, because this is a point, and I'm not saying it cheekily, seriously, because I notice it's been a recurring point that you make, and I'd be curious, probably outside of this arena, what it is that creates such a suspicion around a public functionary, a police officer, for example, who has reasonable cause to suspect that something has happened and would use that, as he is required in law to do,
right, and
to
all
begin
I'm saying
investigation.
That let's balance the rights and responsibilities.
I think we're going back to the issue of time frame was actually raised by the minister. And I think the agreement was we should look at how to coin that in the law for someone who is stopped on the highway and his firearm license authorization, not with him, that he does retain his firearm indefinitely. I think we agreed to that already. And I think it's how that is embedded in it. The issue I raised in terms of when there's issues of investigation, how do you, define that and say
and Chairman, not to cut you, but the reality is that we must accept our realities that we face in Jamaica now, and we have a culture of charge first, or arrest first, and investigate after. And that's what is happening right across the board. So let us just be realistic, and I understand your concerns, but I share the concerns that you share. But the reality all of us face is that the culture is such that your concerns are valid.
As I said, it was raised by the other minister at the very beginning that there should be some constraint on the time you're allowed to detain. And in fact, that was the opening comment of the minister on this particular section of the character. So I think the message was to look at how we can ensure that that is dealt with for the authorized holder. In fact, before you come in, Senator.
I think, Chairman, just to wrap up the discussion.
Yeah.
So where no legal proceedings have been instituted in the courts against a person in respect of an offense, then the firearm or ammunition shall be returned to the person who is proved to be the lawful owner thereof, or if no lawful owner is proved, shall be transferred to the authority for disposal. I think a timeline can be set after the decision is taken about the instituting of legal proceedings in the court. That can be set here at 4.
And the other concern I have...
On the limb of ascertaining who the lawful owner is.
And the other concern I have is in all these cases where a constable takes possession of a firearm, not necessarily arresting the person, but takes possession of the firearm, can we have that some receipt is given?
That's expected. That's not.
To oblige them to give some. I mean, I don't want to say we expect it, but to oblige them to give some receipt.
They must give them some receipt.
And in a standard form type of receipt.
You know, these concerns really raise questions about the standard at which the duties are performed generally.
I saw an article where 8 constables or 4 were arrested and 4 more being sought because they're members of a gang. So just because somebody might be clothed in the authority of a constable don't mean that they're going to be, a person of high integrity. So all I'm saying is let us ensure that there's a balance of rights and responsibilities. So if I am stopped on the road and, the case that I heard earlier on the way down where the person forgot their wallet or their purse and their firearm is taken, that person must have something left with them.
My understanding is that
if the FLA asks them to produce their firearm at some point down the road, they can say who took it from them and here's the form.
Minister, am I right? My understanding is that if the police force sees anybody's property prior to charges, they have to indicate what they have taken and,
Chairman, let us start with the reality and where we are moving the jurisdiction in the broader justice, administration of justice. There can be no dispute that where matters are retrieved and taken from individuals by the police during the course of an investigation, it is to be documented and the person a receipt to be given. I can take no issue with that because it is what is right and proper. Absolutely. And I think that is what is, if it's not explicitly provided for, it is to be included in the Act. And it does a number of things, not only for the person from whom the item is taken, but also as part of the record keeping on the side of the institution. So I take absolutely no issue with that. The other thing is that it must be in prescribed form.
Correct. And also it's important in maintaining the chain of custody as well.
Bear in mind, before you're going out...
To do that, then that's another legal problem on the burden of proof and the standard of proof. So matters are covered in law when issues are raised, because if the chain of custody is broken, and it happens every day in the courts, because you have to maintain the integrity of the evidence, and where there is a chain of custody before the standard of proof beyond reasonable doubt is discharged. It's not a balance of probabilities in criminal matters. And that happens every day in the courts. It's unfortunate that the good news generally not reported, and it's controversy because we thrive on the controversies and, what creates excitement. But it does happen. So...
Also bear in mind that the registrar have to get
standard form receipts for firearm and ammunition and matters that are taken to be supplied, and the receipt is to be prescribed.
Yeah.
Anilo, Ms. McCarthy.
I'm saying, Minister, we just went through Section 88 as well, which means once a firearm is retained, the registrar has to be informed. That's part of what's in Section 88.
The system is not when it's complied with, but when it's departed from and broken down.
Now, what we have to do is, protecting the citizen from it, but also you don't want to provide the legislation that ties the hands of the police and make it impossible to do it.
Right, Chairman, and that is why it is not about setting a time frame within which the investigation is to be done, but progress on the investigative steps certainly would be reasonable internally to find out. And also once a decision is taken, it's not where you're unsure now, you're waiting for more information, you can't because maybe the victim, the witnesses are themselves implicated in wrongdoing. This is when you would have completed your investigative steps, you've assessed what you have, and you've taken a decision. A time frame can be set after that.
Maybe a good sign that the police are identifying their own who are problems.
Of course, Chairman, it is to be heralded and it is to be lauded. It is the same police officers who are accused of corruption and all kind of wrongdoing, those who are upholding the professional standards that are investigating and detaining and arresting their own. And that's in addition to independent investigations by the INDECOM. All right, so we will note 95-4.
Minister, before you move on the issue of the receipt, I'm asking a question in relation to policy because I, just a few days ago, had reason to view a receipt that was given to a firearm license holder when his firearm was taken by the FLA. And the receipt, at the bottom of the receipt, said something to the effect of the authority is not responsible for any loss or damage to the firearm while in the custody of the authority. Now, in my view, that is an unenforceable statement. But the question I'm asking, under the provisions that we visited before, 8081, where a firearm license holder delivers his weapon or surrenders his weapon for whatever reason, whether asked to or voluntarily, what provision have we put in the legislation, excuse me, in relation to the responsibility of the authority or wherever that weapon is surrendered to care that weapon, to ensure the security of that weapon while that weapon is in their custody? I ask that from the point of view of certainly hearing stories in the past of weapons in custody but used in crimes. And I ask that in relation to the exposure to the firearm license holder, if he has surrendered his weapon, but at some point his weapon is found to be involved in some incident while it's purportedly in the custody of the authority or one of the prescribed stations.
Well, I think First Minister has indicated a standard form receipt would be established for, once they, am I right? So that would take care of the format of the receipt. In terms of someone breaching the rules and taking it, that's a criminal act, and it has to be investigated criminally. I don't think you can legislate against that, except it's a criminal act if the firearm is in store, somebody takes it out and commit a breach, because you'd find it, that firearm was used. The ballistics would tell you that this firearm was used in a crime at A and B when it was in the custody of the police station at Matilda's Corner, or it was in the police FLA. It would require a police investigation to find the person responsible and prosecute them. You can't legislate against that being done, because once we are dealing with human beings at any level, and you can breach. If it's breach, it's how these records are kept and how the institutional arrangement in place to identify that it was indeed used, and then the investigators would be the police have to now find the miscreant.
My understanding of the inquiry of Member Golding is at least twofold. One is whether someone who has surrendered their firearm and or ammunition for whatever reason under the Act, whether that person can be charged for an offense in relation to the use of the firearm while the firearm is outside of their custody. All right, so that's one I understand. It would certainly depend on what it is, but I would see a plausible defense. In fact, I would find it untoward, to put it mildly, that an investigation, someone would be charged for the use of the firearm who had divested himself of the firearm lawfully in accordance with the provisions of the Act. I say that though, to say that we have so many instances around corrections where things happen. So I couldn't prejudge except to say that such a person would have to put their defense forward and allow for everything to be before the court. So that's one part of the inquiry, what I got. The other part is what should happen.
Before you move to the other part, just following on that. So my concern then is what protection do we give that person without having to expose them to the expense of mounting a defense? If it is that I have surrendered my weapon to the firearm licensing authority, the authority, ought I not be permitted under this Act to have some protection from the negligence or the deliberate act of someone in the firearm licensing authority who allows my weapon to go back on the street? Should I not have some protection from that?
You would, save and except that we wouldn't be legislating it in the law, but you would have it under the common law, naturally.
And that's the point I'm making.
Yeah, but we can't have the cake and eat it, you know. Because there is no guarantee. While you can guarantee that you may not commit an offense, there is no guarantee that you may not be charged with the commission of an offense. And that is why due process says that if you're charged, you go through the process where the evidence is put, you have an opportunity to present your defense, etc., etc.
The point I'm making is
we won't escape in certain circumstances.
But I'm making the argument, Minister, that it is grossly unfair.
No,
Sure.
My understanding is that the person not be charged unless there's an investigation. They could not be charged because his firearm was stored properly and legally because it was found an offense. A full investigation will be done to see if it's related to him or to somebody else. So all he'll be doing is waiting to see the charges laid against who is the person to be held responsible. He couldn't be charged for the act that was there.
I don't think that's what Minister is saying, that he couldn't be charged.
And I don't think
it's absolute that he couldn't be charged. I guess the question I'm asking is how can we ensure that a person who has handed his firearm over to the firearm licensing authority is exempt from a charge?
I can't exempt him from a charge if he's
But
involved.
how can he be responsible for the firearm if the firearm licensing authority takes it into their custody? That's my question. Why is the law? Why are we holding him responsible?
No, we're not holding him. We're in the.
No, Minister. I'm saying if he were to be charged, right?
I'm saying he could only be charged when the police investigate and find out that he was in fact complicit in the activity. In other words, I put my firearm in firearm licensing authority, then I bribe someone in the authority to give it back to me, commit the crime and put it back. And if the investigation shows that he's a charge like anybody else, it's a criminal investigation. I can't prevent him from a criminal investigation.
I don't see why he couldn't be charged just by virtue of the fact that it is his weapon and he's the license holder.
I don't see how that's... The law is
I don't know that there's a bar to a charge. Just on that alone.
If his firearm in the firearms licensing authority storeroom, I don't see I can charge him.
It would then lend to the case, though. It would then lend to the case and for the prosecution for him to mount his defense. And so what I'm asking is, what is the objection to protecting a licensed firearm holder from having to go through that process if, in fact, he has handed and surrendered his firearm to the authority? Are we therefore saying that if something happens and that firearm goes on the street and causes some havoc on the street, that that person must now be held to defend himself even though he has surrendered his firearm to the FLA? I find that a little unfair.
No, Senator, my understanding is very simple, and as I said, I'm not a lawyer here. If the man surrendered his firearm, I'm not charging him if this comes to a firearm. I'm not charging him. Nobody can charge him if the firearm is used in a felony. He cannot be charged. There's no basis to charge him. The firearm is in the Firearms Authority. However, when the police investigate, if he's found to be part of it, he has to be charged. But he cannot be charged before that. If the investigation leads to him, or whoever it leads to, whether it is the chairman of the FLA, the executive director, investigator, officer, or somebody else, and the owner, then they are charged. Everybody will be. I can't protect him from that charge.
Yeah, but Mr. Chairman, Senator Golding is saying, can we make it explicit that having turned over possession of your firearm, you are no longer liable for the misuse of that firearm? I think it's as simple as that. Because if the FLA itself is putting words contrary to that, to say, notwithstanding on their receipt, that they are not taking any liability for having taken possession of the firearm.
The minister already indicated in discussion that we'll have a standard form receipt.
Chairman, I can only, it's an interesting discussion, but this is the best way I can answer the inquiry, the concerns of Member Golding, right? That every person charged with a criminal offense shall be presumed innocent until he's proved guilty or has pleaded guilty. First thing, every person charged with a criminal offense shall be informed as soon as is reasonably practicable in language which he understands of the nature of the offense charged. Have adequate time and facilities for the preparation of his defense. Be entitled to defend himself in person or through legal representation of his own choosing, or if he has not sufficient means to pay for legal representation, to be given such assistance as is required in the interest of justice. Be entitled to examine or have examined at his trial witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. Have the assistance of an interpreter free of cost if he cannot understand or speak the language used in the court. Not to be compelled to testify against himself or to make any statement amounting to a confession or admission. And except with his own consent, not to be tried in his absence, unless he so conducts himself in the court as to render the continuance of the proceedings in his presence impracticable, and the court has ordered him to be removed and the trial to proceed against him, or of course if he absconds during the trial. So we do have at the highest level safeguards. I don't think we're going to be able to have it, and what they say, have the cake and eat it, but if someone finds themselves in the unfortunate position of being charged for a criminal offense, the most you can do is to ensure that the due process safeguards are adhered to. And that happens every day in the court.
But Minister, the only reason I'm finding myself in that position is because the authority has caused or has omitted to do something to prevent my firearm from escaping into the society. So I'm saying in a scenario like that, let me try it another way. Are we therefore saying that where the authority or whichever police station or entity takes hold of a licensed holder's firearm, that regardless of whether they have been negligent in keeping and caring and storing that firearm, that our policy position is that the license holder must be responsible for the negligence if it occurs. And let me finish the point, please. Don't interrupt me yet. When we do that, when you say that the remedy is that the Constitution provides for them to mount a defense, I am saying to you, I have done nothing wrong. I have surrendered my firearm. Something has happened to the firearm as a result of action or inaction of the body charged with holding and storing it. It has been involved in some incident. Why should I, from a policy point of view, be put to mounting a defense, securing counsel, obtaining witnesses to determine my innocence? I am saying, if what this bill is to do is to ensure a regime for the responsible holding of a firearm, and to ensure that those who perpetuate the illicit trade of firearms and ammunition are come down on in a very heavy way. If that's what we are doing, how does the license holder who has either voluntarily surrendered or surrendered on request, how does holding him to a crime that happens with his weapon further any of the precepts of this bill?
I think we have got a debate. My understanding, I think we have got a non-debate in the Senator. Okay, you heard it. The Minister, in summarizing the statement discussion before, indicated that we have a standard form receipt, which would take care of the complaint you're making, because I said somebody wrote onto that and they have no liability. That I'd expect would not be included in the standard form receipt. So there will be no need to...
You know what troubled me about it, why I raised it, Minister Chang?
Yeah.
Is seeing this receipt, which I believe has been
I'm
issued.
saying to you that it is indicated in the earlier debate that would have a standard form receipt established for all handing over, not only for retention and so forth. So that would be taken care of. That mischief would be covered, not only in terms of the person handing over a firearm, but also in those where they are retained because the person doesn't have the authorization.
So if that is the case, then why would we?
It's not the case. No, that's
no.
what's being
I know
established.
that's to be. I'm saying if that is the case to be, why would we stop there? Why would we not, in saying that this prescribed?
That would be suggesting that if the firearm is used, once you have a standard receipt, it means the holder the storage must have liability for what they have. If it is breached, then it's a criminal offense. You can't.
So we would in setting out the provisions for that prescribed receipt, we would also transfer responsibility for the firearm to the FLA.
Just for the protection of the firearm, any criminal act committed to the firearm have to be investigated by the police, and anybody can be investigated. Owner, police, or firearms authority. You can't protect the owner, anyone at that point. The investigation is the only process to protect him. But the liability of holding it safe is with the storage, the holder with the FLA or police.
So we will say so in this bill?
That's fine. But if it is breach, everybody is investigated.
No. I don't have an issue with the investigation part.
Yes,
it's a question of the liability where it's not in my custody. So if we're going to say that, then I think I'm fine with it.
Okay, Minister. Just before you come back, Minister, you start again, I should have a tender apology for two members who, said for the records, Minister Pernell Charles Jr. I did tender apology for Senator Charles Sinclair and Member Fitz Jackson, who is off there, who were able to come. For the records. Continue, Minister.
Don't you believe I can add anything further to the concerns of Member Golden? I said I don't think I can add anything further to allay your concerns because I think that just right. Proceed.
96, forfeiture of firearms and ammunition. 1, this section applies to the forfeiture of any firearm or ammunition other than a prohibited weapon seized pursuant to this act or referred to the Director of Public Prosecutions under Section 102(2). 2, on the application of the Director of Public Prosecutions to a judge of a parish court, the judge may order the forfeiture of a firearm or ammunition if the judge is satisfied that the requirements under this section have been met. 3, where the Director of Public Prosecutions proposes to apply for forfeiture of any firearm or ammunition under subsection 1, the Director of Public Prosecutions shall give to any person who, to the knowledge of the Director of Public Prosecutions, was at the time of the seizure the owner of the firearm or ammunition, as the case may be, notice that after the expiration of 30 days from the date of the notice, an application will be made under this section for the forfeiture of the firearm or ammunition. 4. Notwithstanding subsection 3, notice shall not be required to be given under this subsection if the seizure was made in the presence of the holder of a firearm authorization in respect of the firearm or ammunition, as the case may be, or an employee or agent of the holder. 5. Without prejudice to any other form of service of notification, notification may, for the purposes of subsection 3, be made by publication in a daily newspaper in circulation throughout Jamaica. 6. Any person having a claim to any firearm or ammunition seized under this Act may appear before the court on the hearing of the application and show cause why an order for forfeiture should not be granted. 7. If upon the application of any person prejudiced by an order made by the court under subsection 2, the court is satisfied that it is just to revoke the order, the court A may revoke the order upon such terms and conditions as it considers appropriate, and B, without prejudice to the generality of paragraph A, may direct that person to pay to the authority in respect of storage, maintenance, administrative expenses, security, and insurance of the firearm or ammunition, such sum as is specified by the court, not exceeding 1.5 times the value of the firearm or ammunition. 8. An application to the court under subsection 7 for the revocation of an order shall be made within 30 days after the date of the order, or within such longer time, not exceeding 6 months after the date of the order, as the court may allow. 97.
Before we go to 97.
Yes, I'm trying to understand the section applies to the forfeiture of any firearm or ammunition seized pursuant to this Act. So, for example, we were in the earlier section 95, a constable who takes possession of any firearm or ammunition, whether pursuant to an investigation which may never be result in legal proceedings, charges or legal proceedings being instituted, would still be available for forfeiture, as I'm reading it under this section. Shouldn't it be at the end of or upon the determination of the matter rather than just once it's seized? Because there are a number of cases in this Act where the weapon could be seized, but then subsequently the matter would be determined and perhaps in the favor of the firearm holder. So should we circumscribe this a little more?
Sorry, just say again.
No, I'm saying the section is drafted so broadly. It said the section applies to the forfeiture of any firearm or ammunition seized pursuant to this Act. Now, I'm saying there are a number of cases, just for example, the previous section, where it said a constable who takes possession of any firearm would have seized that firearm pursuant to this Act. So I'm saying, is it just seizure, or is it upon the determination that an offense was committed that forfeiture should take place?
So if I might, the particular provisions that provide for the seizure also provide for the point in time when the firearm or ammunition can be forfeited under Section 96.
Under Section 96?
Right. So if you notice in 95.3, for example, 95.3A speaks, includes a cross-reference to Section 96 as to when the firearm or ammunition shall be forfeited, and it provides for that forfeiture on conviction.
So in each section, that 96, or that would refer to 96, would also provide a point in time at which the determination would have been made?
It does not usually apply until there's a conviction.
Right,
Post-conviction.
I understand that, but
Right.
just reading section 96 by itself, it doesn't seem to require a determination of the offense. It just says any firearm or ammunition seized pursuant to this act.
Right, but forfeiture comes, seizure and forfeiture is not the same thing.
I understand
Right.
seizure and forfeiture is not the same thing.
Right.
But I'm saying this 96 suggests
So the provision here
forfeiture
applies.
could be applied to any firearm that's seized pursuant to this act. And it may be that in every section that speaks to seizure or taking possession of the firearm, within that section may provide for the point at which it is forfeiture would apply. But I have cross-referenced every section. But if the drafter assures me that like in 95, in every other section where it refers to well, I don't know if taking possession is the same as seizure, but if there are two different things, but wherever the possession is taken of the firearm further to an investigation or charge, that forfeiture shouldn't immediately apply. I'm asking for clarification. I'm just trying to get the scheme clear in my head. So in terms of section 96, in every other section that would make reference to 96 for potential forfeiture, it would be clear that the forfeiture would only apply after the matter is determined. That's the reassurance or the assurance I'm trying to write. Well, it may not always be conviction because, for example, the police may recover a firearm that never results in an offense or in somebody being charged for the offense. They may find it in a location, but it doesn't necessarily mean that somebody will be charged. So at some point, I imagine that weapon would be forfeited and destroyed.
So you can have forfeiture post-conviction, and you can have forfeiture where the firearm or ammunition is recovered and no lawful owner is identified. Essentially, those are the broad circumstances in which the forfeiture can take place. There is a process to get to forfeiture because it comes at the end of the day. And in respect of conviction, post-conviction, an application is made to the court. The matter is referred. So just remind me, other than where the firearm was retained and it has gone through the investigative process, no lawful owner of the firearm, the decision is taken to institute no legal proceedings, and no lawful owner of the firearm has been found. That is one circumstance. What else other than the post-conviction?
There's also the authority could seize a firearm that has not been marked, and that is under clause 29. The customs agency may seize a firearm coming in as well, and those transferred to the authority. There are other instances of seizure throughout the bill, which might not necessarily...
Talking about when do you forfeit?
Which may not necessarily be as a result of a conviction, but still can lead to forfeiture.
All I was saying, whether it's as a result of a conviction or not, but upon final determination of the matter is what I wanted to ensure, that forfeiture couldn't take place ahead of the final determination of the matter. That's my concern.
Fair concern for clarity. The other issue, just check.
Before you go ahead, was there a reason for 96.4 That is to say that if the seizure was made in the presence of, and I'm skipping this, an employee or agent of the holder, that would obviate the necessity for notice?
That's the provision I was coming to.
Oh.
I think there may be a little crossing in the instructions around this. Because if you're moving to forfeit, so where the DPP proposes to apply for forfeiture, notice is given of the application. And that really should have nothing to do with when and where and in whose presence the seizure took place, because it is something different. What you're saying is that I am going to move the court to exercise the power to forfeit it, and then it enables anyone who has a right and an interest, person who have a claim in the firearm, to then make a representation to the court. So this provision is not capturing what it's intended to capture. It will have to be reworked. That's the one which would take care. No, because you are to give notice of your intention to apply for forfeiture, so that anybody who has a right, a claim in the firearm, could appear before the court and show cause why the forfeiture should not be granted.
Particularly something like security firms, this would be the case where an employee is, a firearm.
So this I think the instructions got a little wired there. The non-requirement for the notice cannot be simply because the seizure initially took place, because it's something completely different. Because something can be seized in my presence, but I don't know that you're going to apply to have it forfeited so that I can put the necessary arrangements in place to appear before the court. To have my claim in the property heard and determined. (96)(4) is to be revisited, because the intention is that once an application for forfeiture is to be made, a notice is to be given to enable persons who have an interest. And you note that the notice is given in different forms, including circulation of the newspaper publication in the newspaper. Can proceed. And I think the chapeau, Ms. Grant, you can probably look at it to see if any tidying up in that language at 96.1 could be done.
96.1?
1, just whether language could be added.
Well, yes, I could.
Right.
I have already just to answer.
Member Bunty.
Yes, we could insert after the word forfeiture the word pursuant to section 96.3.
Right. Yes.
All right. So 97, sentences in respect of offenses committed in circumstances that would otherwise be authorized under recently expired firearm authorization. Where a person is convicted of an offense under this Act, A, in circumstances where, had it not been for the expiration of a firearm authorization held by that person not more than 30 days prior to the commission of the offense, the person convicted of the offense would have been authorized under the firearm authorization to carry out the activity in relation to the offense, and B, in respect of which a mandatory minimum sentence is provided, the mandatory minimum sentence shall not apply, and the court shall instead impose such sentence as the court considers appropriate.
That's again,
such sentence or such term, because the mandatory minimum relates to the...
There were some fines as well, so sentence would cover both.
But this 30
mandatory fine? Mandatory amount of the fine? That's not my recollection. in respect of fine?
Yes, but maybe.
No,
the
I
court
understand, but I think we may need to split it out.
I think sentence is correct because the court might decide not to put in a term of imprisonment at all. Okay?
Let's look back on that against the policy. We'll just make a note. I think it was in relation to going below the threshold and not necessarily another form of sentence. But because the sentence is just...
Would still be a mandatory term of imprisonment anyway. Imprisonment
It would be a
mandatory.
type of sentence, but not the threshold in terms of what is mandated. We'll just look back at it.
I understand the policy, and there's a little clarification. And when I read the side, it is activities which would otherwise be considered legal. I understand. Except that his authorization expired recently.
In light of the...
So you wouldn't want the mandate wouldn't apply at all.
Right.
In light... The policy is to cover for those who do something illegal with their firearm.
Right.
And they're not licensed. But since the qualifications for activities were already covered, it would mean that he did something that would be considered legitimate, so the mandatory sentence wouldn't apply. But it needs to be clear.
Mr. Chairman, when we had earlier discussed this thing about the authorization expiring and not being renewed, we had talked about perhaps not criminalizing somebody for not doing it within the window. Right, but I'm saying consistent with that, should we look at maybe something beyond 30 days here? Because you're saying if it was in 35 days, the person would be treated as if they had an illegal firearm.
Well, no, this qualifies here that it would not, the mandate is to apply.
Why 35 and not 36 or 34?
No, I'm saying like 90 days or something more, giving a little more room.
Why?
Just because,
Why wouldn't 30 days as opposed to 7 days or 14 days? Because it started at 7 and 14 and then 21 and now all the way up to 30. To give enough time in circumstances. Or for the necessary arrangements.
No, basically what this says, if your firearm authorization expired more than 30 days, you are treated as if you are carrying an illegal firearm.
Quite, Minister, sorry to interrupt, Minister. It says committed insert that would have otherwise be authorized. First of all, so the activities are defined. It's not, you can't shoot a man with it and get away with it, right? It is activities that you normally be doing. So maybe just target shoot, and therefore the mandatory sentence applies. So you already defined that he cannot come under the prohibited regime. You're just saying that at 30 days he can be charged. And
that's what I'm saying. We've made
but the law says it is in which respect a mandatory sentence is not provided. The court would decide. So it's totally discretionary whether you fine him $5 or 5 months.
But all I'm saying is you are treating someone whose firearm authorization expired 30 days or more than 30 days ago, as if they had a...
No, we're saying he's committed an offense, and that's all it is. It's a breach of the regulation. Because he's now subject to pure discretion of the court. The activities he's being charged for now otherwise would be authorized activities, not being given the exemption of a felon. It's just activities normally. But mean he can carry the gun in a public place, he's going to be carrying it.
No, so in other words, let's say he would be charged for illegal possession of a firearm.
No, it would mean it says in respect of such. It would be a breach of the regulation for which the court would be totally discretionary. 30 days is a good time.
Just to say we have to look back at the provision, not necessarily along the line, but we do have to look back at this
but bear in mind that 30 days is a long time for me. We're talking about a firearm. It's still a dangerous weapon.
So all I'm saying is the policy intent then, Minister, is that anybody who had previously held a licensed firearm and allowed their permit to expire beyond 30 days will be treated as if they were an illegal firearm holder.
It'll be treated as a breach of the regulations.
No, but it says
No, it says
where a person is convicted of an offense under this act. An offense under this act could be illegal possession of firearm. And therefore, if you've been carrying a registered, authorized firearm for 30 years, but you allowed your permit to expire more than 30 days, you are now treated as if you were a gunman or other person held with an illegal firearm.
B is very clear. In respect of such, a mandatory minimum sentence is provided. The mandatory minimum sentence shall not apply, and the court shall instead impose a sentence as the court considers appropriate. And
That is if
and
it
I've known
is-
of people where they have been where the firearm license expired and they were charged $5,000.
But that is if it's not more than 30 days. I'm saying if
Minister.
it is more than 30 days, then this wouldn't apply. They would now fall under the regime of the mandatory minimum.
says-
Hold on,
that
Chairman,
must
a
be
member.
so.
The section is cast too widely. It has to be
Yes.
revisited in respect of, because it's not every offense in the opening words where you're convicted of, right?
But the fact,
So,
Minister, the fact that at 97B, it points to in respect of which a mandatory minimum sentence is provided, it means it's taking it back to the illegal use.
But that's why I'm telling you that the provision has to be looked at. I think
So
there
you're
was some-
agreeing with me then, Minister?
But I said it from day one.
I'd like you
understand.
to explicitly agree with me.
I don't think I'm in a position to satisfy all of your hopes and desires.
Well, look, because the key is the authorized person must be given some respect, which is why we take them out of the prohibited weapons. But they're not giving them a leeway to go out there and fire gun all the time and disregard the license regulations. So 30 days in terms of time is not a short time.
Chairman,
But in
that's
terms of
not
the
the
wording for
concern about the
penalty,
30 days, you know. It's only certain types of offense, the conviction for certain types of offenses under the Act, not any offense under the Act. And then we will have to look back for those offenses. It wouldn't be offenses where you would have had. Well, let's just say with the
I
team,
said
MNS.
the side, what
We
we
will
call
come
it,
back
the side.
to the committee.
And the law, the side says it clearly, for offenses committed in circumstances that would otherwise be authorized, that means not illegal activity. It means if you carry a firearm going to the airport when you shouldn't go there, you can charge you with something and you should be charged. Quite frankly, it means you walk into a public space and your license you have not paid the license. You should be doing it because if you use it in there, it causes a big problem.
And precisely for that reason,
That's
why
what-
we will
that-
have to
that's-
revisit the provision because it's not just
If a man carry a legal
offense.
firearm or prohibited weapon in a public space, him get mandatory sentence. In this case, he has a right to do so. So you remove it. It's not a big issue. I'm a layman. I don't see the word confusing. It is quite plain to me because it says there.
The minister is not a layman and she has already agreed with me, so I won't argue
Well,
with
maybe
you.
that's the
Mr.
problem.
Chair.
When lawyers are going to this guy, their problem. It says clearly offensive.
But Minister, while we're on this clause which deals with mandatory minimum, I wonder, not necessarily now, but if someone could provide this information for me, how many guilty pleas have been made under Part 1A of the Criminal Justice Administration Act that was inserted in 2015 by an amendment to the Act? And it would be good to have it broken down by year and the offense to which the guilty plea was made. Sorry? Yes, and then this is as opposed to the formal plea bargaining agreements that have been concluded under the Plea Negotiations and Agreements Act 2017. So I would love to see how, you know, the two types of guilty pleas, you know, where you could get consideration for an early.
Access to information, apply to the court for it.
No, but
Registry
Minister.
of the gun court. No, I mean, it's not a complicated
Minister,
process.
you
Your
know,
penchant for data and disaggregated
I'm
data
asking
is large,
as a
and I
member
understand.
of a joint select committee, which is reviewing a bill which makes provisions for these mandatory minimum. Is it unreasonable as a member of this committee to ask that the data be provided to show how the previous arrangements, the two types of arrangements for early pleas have worked over the last 6 or 7 years?
From my perspective, it's not unreasonable at all.
Okay, but so why would that not be provided by one of the officials who are providing data and information to this committee rather than referring me to the Access to Information Act? I mean, you know, with respect, Minister, that I think was not necessary. So, Mr. Chairman, could
What
I...
did we decide to do about 97?
No, but
it's still-
before you move on, Mr. Chairman, could we get that
there's
information?
agreement that, we'll get the data for you, in due course, Senator, but in 97, my understanding, the legal advice is that we should look at the opening sentence. I mean, I don't see a fault, but the law
Sorry,
doesn't tell me
Chairman.
that.
Fun and joke aside, I don't know how that data would assist in respect of this one, if what you want.
It wasn't specific to this clause. It
right.
was
So my
respect to
response was because
Right.
I thought it
No,
related
it wasn't
to this
specific
clause,
to
and
this.
I didn't
I said
see
when
the
we're
relevance of it.
just dealing with the mandatory minimum sentencing, which is provided for in this bill.
I'll ask. I can ask for the information through the Council of
You get
Justice
the information, not a problem.
avenue. And it would be quite interesting because I know a lot of concern has been raised. Like I say, my comment and direction to you is because I concluded that you were asking it in respect of clause 97, and it was my respectful view that it did not arise in respect of that. But now that you indicate that it was a wider request, I think it's interesting because concerns around sentencing and whether at the end of the day the sentence handed down by the court has been an appropriate sentence in circumstances involving the firearm is one that would be enlightening to us. We get to the information in discussion because that was part of the concern around sentencing too, where essentially the provisions were being used or seemed to be used as a backlog clearing tool. And sometimes the aims of sentence were not appropriately considered, it appeared, from the concerns raised.
The police has data we can use, and if you wish to get from the court's office to be more specific, fine.
Can't help it. Do forgive me. But this 97 bothers me. And let me tell you
I
why.
understand. What
Where-
aspect?
Let me tell you where, though. So if a person is convicted of an offense under the Act, then that offense has a penalty, carries a penalty already. Isn't that so? So the only purpose of this section, it seems to me, is to ensure that while if he has committed that offense, but his firearm has not been license has not been renewed, is to exempt him from the mandatory minimum. And that is a policy. If you are doing a policy which clearly separates illegal from legal, the question is, does this evil belong there? Because what you're saying is that normally he would be in illegal possession of firearm because it's not renewed, simply because it's not renewed, because he previously had authorization, but he has not renewed for 30 days. So that makes him in illegal possession, and what this clause is saying is don't apply the minimum, mandatory.
If I may, Chairman, during the course of deliberations on previous clauses, the committee agreed on certain matters as to when a prosecution would come in. So the policy really is that, start again very simply, is that the law intends to treat persons who interface with firearms that have been lawfully traded and that are registered in the database and recorded differently from those who interface and use the firearms that have been illicitly trafficked. It's a starting point. Second thing is that for persons who have been deep vetted and duly authorized to hold a firearm that is registered in accordance with the Act would be treated a little differently again, because it is not the intention to criminalize persons who would have gone through a process to hold a firearm, but that is with a caveat, notwithstanding obligations are placed on persons who are authorized, and it is the expectation that you will comply with those obligations. But we do not need to go as deep and far, because if the system, when activated, works well, it means that you can trace the firearm back to someone, and that takes a lot of the problems that we have been facing, out of the mix of problems. And so this really was to say that, look, first of all, we're going to give you a chance for any of the obligations imposed on you, especially the general one. There are some specific ones that are strict liability. There is really no getting out of it, especially the restricted area permit, because that can only be given to somebody who's already authorized, who's a licensee holder. And there are strict compliance, because there would be particular public safety, public order and security reasons why the minister would exercise the power to declare a particular area a restricted area for the purpose of firearm. But the intention is that if you fail to comply with the obligations, most of them, not all of them, then you would be given an opportunity to be complied with, to comply. We also accepted from the deliberation that we would consider dealing with some of these matters from an administrative standpoint, so that if you don't come in when you should come in, then you may be fined a little higher, and for every day further. But it would cause someone to wonder, it would cause the authority to wonder, what is the reason why you are refusing to comply with the obligation that is placed on you? If there is a proper reason, say the pandemic has broken out, you can't come in, you're sick, a member of your family dropped dead, you're in bereavement, circumstances that you can understand, then time is provided. But that time is not in perpetuity, it comes to an end. So these provisions were intended to kick in after you would have been given the latitude to comply and you fail to comply. So that's what is intended. But I think we will have to look at it in light of what we had accepted in earlier deliberations on some of the clauses and the revisiting of it. And then it was not intended to, you don't know what offense could trigger from someone not establishing that they are authorized to hold the firearm. But no, under the new system, it is not just the person who would be in a position to say, I have a license, because the system that we are putting in place is a system that should have the integrity to record all authorizations given, to record details about all firearm. So unless it's a massive breakdown, the breakdown would have to take place on both sides of the divide for you to not know eventually, but we're not yet there. And that's why different time frame is going to be appointed for different provisions to come into effect, and we will have a transition period. Because this whole purpose is to clean up. And after we get to the cleanup, persons on the authority side will also be held strictly to account, as well as those on the public side. So this provision has to be relooked at against
what I want to
previous
ask,
discussion.
clarity, I've got the legal. My understanding of this here where it fits in the policy. One, you're separating the legal from the illegal firearm. But if the person doesn't license his firearm at the time, there's a breach, there's some legitimacy issue. But the issue being addressed here, which has to be addressed, is that let's say a licensed firearm holder who has not relicensed his firearm discharges firearm on a highway, which is illegal, not a matter of a felony thing. He would not be charged under the Prohibited Weapons Act. That's my understanding of this here. That's all it means. He would not be charged under the Prohibited Act. And this has to be put in here explicitly because he now has, we have already separated him from the crowd from the illegal firearm. So, but he has not relicensed the firearm within the 30 days required. Therefore, he breaches the Firearm Act, but it will not be charged. It will not be treated
even if he were authorized currently, he still would not be authorized to discharge his firearm in a certain
it's an act.
right.
That's what my reading of the sentence.
And that's why the any offense is too widely cast, among other things.
Right.
Any is any offense rather. '98, Ms. Grant.
98, circumstances that may be regarded in determining fines. In determining the amount of any fine to be imposed in respect of an offense under this Act, a court may have regard to A, in the case of a body corporate, 1, the nature of the business, 2, the size of the business concerned, including the level of profit or the total revenue generated by the body corporate, B, the nature of the offense committed, C, whether the offense was committed for the benefit of a criminal organization or was committed for profit, and D, any other factor that the court considers relevant. 99, factors that shall be...
If you choose to do gun running and you make big profit, be prepared to lose everything. Continue.
99, factors that shall be regarded in determining sentence. In determining the severity of any sentence to be imposed in respect of an offense under this Act, a court shall have regard to A, whether the offender has been previously convicted of a firearm-related offense, or B, whether the offense for which the offender is convicted is in connection with the commission of an offense under this Act by a person under the age of 18 years.
I think this provision also has to be reworded to take into account the mandatory minimum provisions, because it's any sentence to be imposed. I know it's minimum and it can go up, but I think we may just have to.
I'm wondering also if this was intended, because 98...
And it's intended for the other side.
This is intended to deal with imprisonment, sentences of imprisonment.
Right, so we'll have to revisit this one.
Okay. (100) Proceedings in relation to person under the age of 18 years. Proceedings against a person under the age of 18 years in respect of any offense under this Act alleged to have been committed by that person shall be dealt with in accordance with the Child Care and Protection Act or the Gun Court Act, as the case may require. 101. Punishment, proof, and records in respect...
To point out that where a minor is charged alongside someone, the Gun Court Act provides that they can be treated as an adult.
One.
It depends on what the circumstance, generally, yes. Not new. Not a provision under the Gun Court Act.
1, for the avoidance of doubt, a person who aids, abets, conspires in, or procures the commission of any offense under this Act, whether by financing the commission of the offense or otherwise, shall be liable to be tried and, upon conviction, therefore, to be punished in the same manner as may be applicable to the principal offender.
Just to pause and say, I recall seeing a report on a comment I made on the principle that is captured here at 101. Just for those who are watching and listening, this is an established principle of law. If you aid and abet the commission of an offense, you're liable to be tried and punished in the same manner as the principal offender. So it's an established, it's a hollowed principle of criminal law.
If I may, however, Minister, this was something that we had actually had some serious consultations with the Office of the DPP, and they were the ones that insisted that we ensure that we include a provision similar to what is here now.
That is why it's also for the avoidance of doubt. Yes.
2, the penalties specified in the 6th schedule shall have effect in respect of the offenses under this Act specified with respect thereto. 3, the Minister may, by order subject to affirmative resolution, amend any monetary penalty specified in Part 2 or the 6th schedule. 4, in any proceedings against a person for an offense under this Act, the production of a certificate signed by the Director or of the Institute or the Chief Executive Officer of the authority, as the case may require, shall be sufficient evidence of all the facts stated therein, unless the person charged requires that the Director or Chief Executive Officer, as the case may be summoned as a witness, in which case the court shall cause the Director or Chief Executive Officer, as the case may be, to attend and give evidence in the same way as any other witness. 5,
wouldn't it be, though, to be cross-examined? Because you'd be, I think we need to check this provision. Because the certificate and the information would be prima facie evidence. If it is accepted, it becomes it's accepted. Where it is not, it would be for cross-examination. Just check, I'm not sure. This is what I'm kind of recalling.
Reproduces how this type of provision is treated elsewhere. Not that saying that's right.
For cross-examination?
It's consistent with the formulation.
Mm-hmm. We'll just check it.
5.
What it means is that so the certificate would be the prima facie evidence. So it's not that you're coming to establish afresh the process, but you would enable cross-examination on what is supposedly contained in it.
Just merely pointing out that this is how the formulation is in other laws. I'm not sure if...
I know.
Mm-hmm. Okay. 5, where a person is convicted of an offense under this Act or of an offense against the Customs Act in relation to the import or export of firearms or ammunition, the court concerned shall cause the conviction to be certified to the board. 6, where a provision of this Act provides that a person shall be sentenced to imprisonment for life, that provision shall apply notwithstanding Section 44 of the Interpretation Act.
So that section that says the penalties specified in the 6th schedule shall have effect in respect of the offenses under this Act, specified with respect thereto, are all the offenses, every offense created under this legislation, is the penalty provided in the 6th schedule? So can you just direct my mind to where in the Act it covers offenses which are not specifically provided for in the 6th schedule, Mr. Bailey?
So if the offense is one that concerns a prohibited weapon, those penalties will be prescribed under Part 2. If it's for all other offenses, the penalties are prescribed under the 6th schedule.
I was actually just looking at 93(1), where it says a person who fails to comply and so on commits an offense. I wanted to know the penalty, but I'm not seeing it in. If you can just point me to where, for example, the offense created in 93(1) is covered in the 6th schedule.
The reference actually.
Because that, pardon me?
It is actually at 93.3.
The offense is not under 93.1. It's a failure to comply. It's at 93.3.
Oh, thank you.
And then that is provided for on page 1.
No, I saw 93.
107. Penultimate failure to produce a firearm authorization, 90. Right, so there's a difference, as you would know, probably just not seeing it, where the offense is committed, where the offense is provided for.
So the assurance is that all of them are provided for in 6th schedule.
No, that is provided for in the 6th schedule because some of the penalties are prescribed in the provision, in the offense creating provision.
Absolutely.
So it's we still have a dual way of drafting. We were moving to kind of codifying the offenses and the penalties, so you look to have the pros and the cons.
To which one? To the schedule?
Right.
Or to the provision?
Well, I mean, when I was in another place, my preference is for whatever is there. So when you look at it, just for time, user friendliness, you see it there. So where the offense is created, the penalty, that's my preference, just from my time in another place. But, sorry, Mr. Grant?
Indicating that's my preference too, but increasingly...
I wouldn't have known that. Well, going forward, you and I are going to be united in our preference because it's reader friendly. You know, something that, having had the experience...
Glad, Ms. Grant, that I made the observation because at least there's agreement about the better way to proceed.
Well, our clients seem to prefer to house things in schedules.
I've wondered, and I mean, they would know internally that I've always complained because my view is that when you pick up a piece of law, you must be able to find as much as possible. So if you notice that when we reference a section, we give an indication of what the section deals with, and that is increasing the user friendliness of the law. So
it's also easier for the drafter because
but
we don't
Ms.
then
Grant,
have to
you know,
jump
all
through
along I
hoops to
thought the
describe
other way
it
was
in a
your
schedule.
preference, but we shan't talk about
we act
that
on instructions, Minister.
So, Minister, then, it wouldn't be too late then for us just to take those provisions in the schedule and place them in the body?
Not necessarily. We'll see, but I don't want to increase the workload of...
But it's not increasing the workload. There's no drafting in exercise in that, is it? It's really just moving.
Affect the decision going forward whether this is
Yes.
the amendments made here are going to result in a redraft,
Generally-
a total redraft.
So, hold on, I'm not hearing you, CPC, sorry.
It's a lot of work to redraft and re-put the provisions.
I get that,
A
Minister.
whole lot in terms of
I get
timing.
that.
But certainly, Ms. Grant is a
But we have
senior...
severe amendments to make anyway. So I'm saying if this is a bill that we are asking citizens to be aware of their obligations, can't we do it in a simpler way? And I don't make this point lightly. I think, you know, and to Minister's point, when we're asking people to observe things that have to do with their liberty, then it must be easy for them to read it. It must be as easy for the street vendor to read it as it is for the PhD up at UWI.
Golding, having said that though, I think part of the change came about because we were now delegating the power to amend by order subject to affirmative resolution of the monetary penalty. So there is a rationale for it, and it would be more easily provided for that way, where you reference the schedule with the monetary penalties, and then you empower the relevant minister to update, because we have had a major problem of the outdatedness of monetary penalties, causing its own set of injustice. So usually there is a reason for doing it, but everything has pros and cons. Don't worry, we will deal with it in the Ministry of Legal Affairs, since that falls squarely within our shop.
Can I look at domestic? We're going to 102 now, right? Miscellaneous, section 10? Am I right?
Yes.
Minister, before we move into it, can I make a suggestion? We have the day some did order lunch, some did not. And Mr. Richard, right? Did you order lunch? Right. But what I suggest, can the team have the resilience to go straight till 2 o'clock and we really terminate at a late lunch and don't reconvene, rather than take lunch and come back at 3 o'clock, 2 o'clock? What's the mood of the technical team?
From the faces of the technical team, they look like they want their lunch. And I see my Miss Wilkins.
No, I'm asking you.
My Miss Wilkins, who expects protection from her minister.
I was saying we take a late lunch at 2 o'clock. And for public health officer.
But, Chairman, we're making such good progress. Let's give the team the lunch time.
No, I'm with you now. I was just asking an opinion. We'd finish at 2, period.
Well, sorry? We're hoping to at least complete the major provisions, and we have a short way to go. I think we're in the last part before we get to the schedule, and we have gone through most of the schedules when we did the provisions.
Yeah, what I'm effectively asking is take a late lunch. Okay? If we break for 1 hour, we'd come back and finish at 3, but since the others might just want to go, just go to 2 o'clock if the team feels available.
From the technical team, we're fine going on till 2.
Okay. All the way down to...
Can we just have a 5-minute break?
Eh?
Just
we can...
Just a 5-minute break.
You know,
to
get the
stretch
mind,
the legs.
recharge, get some more water and coffee and restroom, but we could go through. That makes sense. Let's go till 2 o'clock. I'm going to suggest we distribute the matrix today. And so we are doing virtual tomorrow. All right. I will still distribute the matrix, but we can do all day up to Friday this week, you know. But I'm going to suggest we do virtual both tomorrow and Thursday. Mr. Technical team, I'd suggest we may have to ask 2 of the submissions to come in. Maybe it would be better to have those face-to-face in a morning session on Friday. The Senate Day, just a morning session for the GRA and senators. It's a normal day, so we'll do that one face-to-face to see GRA and JDF. Those are 2 big submissions. We have anything from Norman Manley Law School? No. The others will go to the matrix together. Yeah, this Friday.
I didn't. What day you
I'm
said?
suggesting that we do all day this week. We do tomorrow and Thursday virtually, and we do a Friday morning session only to look, inviting 2 of the submissions, which is the 2 main ones are GRA, which covers a lot of the things that people have, and JDF.
So you're proposing to meet Tuesday, Wednesday, Thursday, and Friday?
Well, let this thing and done. We'll finish. But 2 virtual days and another. It'd be a good signal that we want to find it through. Because by Friday we should be finished the bulk of this thing.
Could I ask then, if you're going to do that?
And then we break for a while after that.
Could I ask that Friday be a hybrid meeting?
Well, the hybrid, yeah.
Because I'd really intended to be out of town.
All right, we do virtual Wednesday and Thursday and hybrid on Friday.
Hybrid on Friday, thank you.
Minister, I'm sorry, I would have difficulty at this point scheduling for Friday because I would already have matters scheduled. So that would be difficult.
Senators normally meet on Friday, so I figured that
No. But when I knew the Senate wasn't meeting, so I had moved matters to that.
We did hybrid and ask you to. I see you have a nimble between the 2 computers. We could.
Not when I'm on the floor, Minister.
Maybe though the Friday could be used by Chairman, maybe the Friday could be utilized by Ms. McCarthy to put some of the record. We look back at it because we have to also tidy up the administrative side of the committee.
All right, so the agreement, Mr. Wade, have be fresh. Have enough time. 5 minutes to stretch.
Since we appreciate the contribution of all members, especially those vocal ones, we may reconsider Friday and allow that time for administrative matters to be dealt with.
Yeah, the timing seems that we should finish in the 2 days, pretty much all we're doing. But when do we take the... We do Thursday hybrid and bring the JRA and the JDF? So it looks like we're getting through the main thing today and tomorrow. Yeah. Yeah, I think we need some presence when we're doing the JRA and the other. All right. It'll be 11 o'clock.
People always say government must be held accountable. But it's whose job to keep government accountable, and what that really mean? Well, you see, when ministers and public officials have to provide answers for decisions made and can face consequences for those actions and decisions, that means they're being held accountable. Keeping government accountable is a key responsibility of our elected representatives, and the Parliament provides special tools or mechanisms just for this. As citizens, we need to understand how they work so we can play our part to ensure that the members of Parliament we elect are using the tools and doing their job well. Here are 4 of the primary tools you should understand and talk to your MP about. Tool number 1, Ministers' Statements. To effectively monitor the government, MPs need to stay informed. Every Tuesday when Parliament sits, different cabinet ministers are scheduled to give an update on decisions they're making on our behalf. These updates are called Statements by Ministers. They cover a wide range of national issues that other MPs, media, and citizens may have questions about and wish to examine further. That brings us to tool number 2. What you do when you want information? You ask questions, and that's why we have question time. Both opposition and government MPs can submit questions to the Prime Minister or Cabinet Ministers for details on, for example, how a contract was awarded or expenditure to purchase tablets for schools. So if you ever have a question for a government minister, try asking through your MP. After all, that's why they're your political representatives. They should represent your questions and concerns to the government. Tool number 3, Parliamentary Debates. When cabinet ministers present the government's proposals for new policies, laws, and programs, parliamentary debates allow both opposition and government MPs to air concerns, make suggestions, and endorse proposals. If you ever watch those debates, you know they can get a little fiery. But the debate is important, as it informs decisions and continues until a vote is taken on the way forward. Then we have tool number 4, Parliamentary Committees. The general sittings of Parliament are not always sufficient for detailed examination of government work, so oversight committees are formed using government and opposition members to do just that. Some committees like the PAC and the PAAC are in place for an entire parliamentary term. Their job is to monitor the use of public funds to find ways to increase value and efficiency while reducing waste and corruption. Cabinet and state ministers are not appointed to oversight committees since they are a part of the government. Some committees are formed when a need arises. For example, joint select committees are formed to review draft policies or legislation or to probe other matters of serious national importance. Members of these committees are both opposition and government MPs and senators, and these committees will usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
Reduce your risk of viral illnesses like the flu and coronavirus. Wash your hands frequently with soap and water. Cover your nose and mouth when coughing with a tissue and dispose of it. Avoid close contact with anyone with the cold or flu-like symptoms. If you think you've been exposed to COVID-19, stay home, self-isolate immediately, and call 888-1-LOVE. That's 888-663-5683. A message from the Ministry of Health and Wellness.
We work to make communities safer by essentially looking at the structures in the community that contribute greatest to social capital building. Try to reinforce, build, and establish those structures in a way that the community can sustain their own safety and own their own peace. When we say, for instance, we're doing a zinc fence removal program, what we're really doing is improving the line of sight. If you're on the street and you can see better what is behind the fences, then as you walk along the street or children play on etc., you're able to contribute to crime prevention. We believe in terms of our mandate and our responsibility that by making communities safer, we can make Jamaica safer.
With the Easter in between.
I think we're good to go, writers? All right. Part 10, Clause 102. Madam CPC.
102, authority may auction or destroy firearms and ammunition. Where any firearms or ammunition, whether defective or otherwise, other than a prohibited weapon, have been A, voluntarily surrendered to the authority, B, seized or recovered by the authority, C, left in the custody of the authority beyond the time specified under Section 81(1)(b), storage fees, release of firearms and ammunition, D, transferred to the authority by 1, the security forces upon being seized or recovered under this act or any other enactment, 2, the Jamaica Customs Agency pursuant to the Customs Act upon being seized under that act, or 3, the Institute, or E, forfeited under this act. The firearms or ammunition may, subject to the written approval of the minister, be auctioned or destroyed as the authority considers appropriate. 2, the authority shall not auction or destroy any firearms or ammunition mentioned in subsection 1B or D and concerned in any criminal proceedings unless a forfeiture order is granted under Section 96 in respect of the firearms or ammunition, as the case may be, and shall refer the matter to the Director of Public Prosecutions for the purpose of obtaining the forfeiture order. 3, firearms and ammunition in the possession or control of the authority and that have been used or alleged to have been used in any criminal activity shall, as soon as practicable, be A, in the case of firearms, marked, B, securely stored, and C, destroyed if no longer required for the purposes of any legal proceedings. 4, where a prohibited weapon is seized or recovered by an officer in any circumstances under Part 8, the officer shall make an application for a firearm destruction authorization or an ammunition destruction authorization as the case may be, as the case may require. 5, in any case where proceedings are brought against a person in connection with an offense concerning a prohibited weapon, the application under subsection 4 shall be made only after those proceedings have been finally disposed of, regardless of whether or not the person is convicted of the offense. 6, records of all...
Regardless of whether or not, or regardless of whether?
Regardless of whether or not.
But the regardless wouldn't take care of the not? Don't know, just asking. Just seem a little...
Could say either way.
Whether or not, or... You can look at it.
6, records of all firearms and ammunition auctioned or destroyed under this section shall be maintained in accordance with Section 88, National Firearms Register. 7, subject to subsection 8, the proceedings of sale from an auction conducted under this section shall be applied as determined by the authority. A, to the expenses associated with carrying out the auction, B, to the original and legitimate owner of the firearm, and C, to the general administration of the authority. 8, subsection 7B shall not apply in respect of firearms or ammunition that are forfeited. 9, the authority shall, prior to auctioning any firearm or ammunition by virtue of subsection 1, no less than 1 month before the date of the auction, publish a notice, A, in the Gazette, and B, in a newspaper in daily circulation throughout Jamaica, of the authority's intention to auction the firearm or ammunition. 103, appointment of valuator. The authority may appoint a valuator having expertise in the valuation of firearms and ammunition to determine the value of any firearm or ammunition if the authority considers it appropriate to do so. 104, confidentiality. 1, every person having an official duty with or being employed to the authority or the institute shall, A, regard and deal with as secret and confidential all information, 1, stored in the register, or 2, received by the authority or institute, as the case may be, in connection with any application under this Act and from which a person can be identified. And B, upon assuming such duty or employment, take and subscribe an oath in such form and manner as shall be prescribed. 2, the obligation of secrecy and confidentiality under subsection 1 shall continue after the official duty or employment, as the case may be, has ended. 3, any person to whom information is communicated under this Act shall regard and deal with the information as secret and confidential and shall not disclose the information except as A, permitted by 1, the registrar in writing in the case of information stored in the register, 2, the authority or institute, as the case may be, in writing in the case of information referred to in subsection 1A2, B, required by the order of a court, C, required for the purposes of the investigation or prosecution of a criminal offense, or D, otherwise permitted under this Act or any other law. 4.
Otherwise than what? Ms. Grant.
When you read it from the chapeau down,
The person to whom information is communicated under this Act shall regard and deal with the information as secret and confidential and shall not disclose the information except as otherwise permitted, or is it except as permitted? Because the prohibition is on the treating of it, and then you can only, with the exception.
Well, it relates also to the word shall deal with as secret and confidential. So it's except as, such dealing shall be except as otherwise permitted under this Act or any other law.
Good.
4, a person who contravenes subsection 3 commits an offense. 105, regulations. 1, the minister may, subject to subsection 2, make regulations for the better carrying out of this Act, and in particular, but without prejudice to the generality of the foregoing, for prescribing A, anything required or permitted by this Act to be prescribed, B, the fees payable to the authority under this Act. 2, regulations which relate to any matter falling within the functions of the authority shall be made after consultation by the minister with the chairperson of the board and with the chief executive officer. 106, amendment of 1st, 2nd, 3rd, or 5th schedule. The minister may, from time to time by order, subject to affirmative resolution, amend the 1st, 2nd, 3rd, or 5th schedule of this Act. We had concluded that there was a mechanism in the 4th schedule itself which allowed for addition. We had agreed to expand it. Right. 107, minister may exempt person or other entity. The minister may, by order subject to affirmative resolution, exempt a person or other entity from any provision of this Act for a period specified in the order. 108, service of notices.
TPC, may I ask on that clause 107, that's a very serious provision in my mind. If the minister can exempt me from a provision of this Act, he can also exempt me from an offense, he can exempt me from prosecution. Sorry? 107. Oh, 107. I'd love to understand what's the mischief that you really are trying to attack with this provision, 1.
Affirmative resolution.
Right, and affirmative resolution is a majority vote. So, no, so yeah, but we're putting into law certain offenses under this Act, and we're in the same act saying that the minister can go to Parliament and the government side can vote that, okay, this person will not be subject to this offense? Where else in our legislation do we have something like this? I'd love to know.
This is referring again to this section of the legislation. This is not the prohibited, this is with the regulations of...
No, Minister, it's the entire act. The entire act, it's not this section.
So my note is that it's drafted a little too broadly because it was not the intention for anything. But do remember that, well, let me leave it to Team MNS for now.
Yeah, but Minister, when did we get in the practice or the habit of giving the minister the power to exempt people from the law that Parliament has put in place?
The wording's a bit broad here now.
So that's why so if it's worded broadly, what I'm asking is, who is it that you want the minister to be able to exempt in whatever the circumstances that you are considering? Can you just help me to wrap my head around that, please?
So in contemplating some of the situations that may warrant an entity or an individual being exempted from the provisions of the Act, say for instance there would have been an entity conducting brokering activities on behalf of the state. The state itself is exempted from the application of the Act, but that individual is not exempted from the application of the Act. Because they're acting on behalf of the state, there may be necessity in that specific case to exempt them.
I thought as much that you were probably looking at the brokering and the manufacturers and that kind of a category. So if you have that spelled out in your policy, then would you then consider limiting this clause somewhat, because it lends itself too easily to abuse, I think.
So part of the challenge that we face is that we can't necessarily contemplate all of the scenarios and situations and entities and individuals from the outset. The point is made, though. The point is made that if Parliament sanctioned this piece of legislation, and at that time, because it's subject to affirmative resolution, they are then sanctioning that exemption to that individual.
I accept that.
Okay.
I accept that.
(108) Service of notices. Any notice required or authorized by this Act to be given to any person may be A, sent by a registered post addressed to that person at the person's last known or usual place of abode. B, in the case of the holder of or applicant for a firearm authorization, by electronic mail to the electronic mail address provided by the holder or applicant, as the case may be. Or C, in the case of the holder of a firearm dealer's license, firearm broker's license, or a firearm manufacturer's license, or of a gunsmith's license, delivered to any place or premises in respect of which the license is granted. 109, documents. 1, a document purporting to be an extract from or a copy of any other document kept under this Act and purporting to be certified as such shall, in any court and upon all occasions, be admissible and be prima facie evidence of the truth of the matter stated in the original document without the production of the original document. 2, the information contained in a document referred to in subsection 1, kept for the purposes of this Act, shall be provided to A, a constable who requires it for the carrying out of that constable's duties. B, any person authorized by the minister to demand the information. Or C, in respect of any information relating to a person accused of an offense under this Act or regulations made under this Act, that person or any person authorized by that person on payment of the prescribed fee. 3, for the avoidance of doubt, the provisions of section 104 confidentiality, shall apply to a document disclosed to any person under this section or under any regulations made under this Act. 4. An institution or person keeping a document under this Act shall, at the request of a constable or other person authorized by the minister, confirm whether certain information corresponds to the information contained in the document if that constable or other person, on reasonable grounds, requires confirmation of the information. 110. Service on or delivery to the authority. Where any notice, document, firearm or ammunition or other thing is required to be served on or delivered to the authority under this Act, such delivery or service or delivery, as the case may be, shall be effected on the Chief Executive Officer or such other employee of the authority authorized in writing by the Chief Executive Officer for that purpose. 111. Exemptions. With the exception of sections 29, marking of firearms, and 68, grant of firearm authorization by a minister, this Act shall not apply, A, to any firearm or ammunition the property of the government of Jamaica, except when such firearm or ammunition is 1. In the possession of some other person other than a person authorized by or on behalf of the government of Jamaica to be in possession of such firearm or ammunition in the lawful execution of the last mentioned person's duties, or 2. Used otherwise than in the lawful execution of the person's duties in the case of a person authorized by or on behalf of the government of Jamaica to be in possession of the firearm or ammunition. B. To any firearm or ammunition or signaling apparatus or ammunition, therefore, forming part of the equipment of any vessel or aircraft or of any aerodrome at any time when such firearm or ammunition or signaling apparatus or ammunition, therefore, is on board such vessel or aircraft or at such aerodrome, as the case may be, subject to such conditions as may for the time being be approved by the minister. C. To any slaughtering instrument, the property of a municipal corporation or of the Jamaica Society for the Prevention of Cruelty to Animals, or of any prescribed person, except when such slaughtering instrument is 1. In the possession of some person other than A, a person authorized by the municipal corporation or by the Jamaica Society for the Prevention of Cruelty to Animals, as the case may require, under this section, to be in the possession of such slaughtering instrument, or B, a prescribed person, or 2, being used for a purpose other than for the purpose of slaughtering or stunning animals. D, to any conventional arms which are the property of the government of Jamaica. E, to such firearms and ammunition, the property of the government of such other country, in such circumstances and subject to such conditions as may for the time being be approved by the minister, and to such persons in respect of their possession thereof as may be so approved. 112, Review of Act. This Act shall be reviewed after 7 years from the date of the earliest day appointed under Section 1 by a committee of both Houses of Parliament appointed for that purpose. 113, Repeal of Firearms Act 1976 and Transitional Provisions. 1967. The Firearms Act 1967, hereinafter referred to as the Repealed Act, is repealed. 2. The holder of a firearm authorization granted under the Repealed Act, other than a firearm user's permit, firearm user's employee's certificate, or firearm user's secondary certificate, shall A, in respect of any firearm which on the appointed day is in the possession of the holder of the firearm authorization, other than a firearm import permit, deliver the firearm to be marked in accordance with the requirements of this Act, no later than 3 years after the appointed day. B, in respect of any firearm which on the appointed day is in the possession of the holder of a firearm import permit, in respect of the firearm, deliver the firearm to be marked in accordance with the requirements of this Act, no later than 1 year after the appointed day. C, in respect of firearms, the property of the government of Jamaica, where the firearm is in Jamaica on the appointed day, deliver the firearm to be marked in accordance with the requirements of this Act, no later than 3 years after the appointed day. Or D, in respect of firearms, the property of the government of Jamaica, where the firearm is imported into Jamaica after the appointed day, pursuant to an authorization granted before the appointed day, deliver the firearm to be marked in accordance with the requirements of this Act no later than 3 years after the appointed day. 3, during the relevant period specified under subsection 2, the holder of a firearm authorization in respect of the firearm concerned shall not be liable for failure to deliver the firearm to be marked in accordance with the requirements of this Act. 4, the Institute shall, no later than 2 years after the appointed day, procure or cause to be procured the requisite technology to facilitate the storing of information in accordance with Section 88, National Firearms Register, and any information compiled within that period of 2 years shall be deemed to be a part of and for the use specified in the register. 5, subject to the provisions of subsection 6 to 11, on the appointed day, all persons holding permanent appointment to offices under the former entity shall be transferred on secondment to the service of the authority for a period of 6 months or such longer period as the authority may, in special circumstances, approve. 6, during the period of a person's secondment to the authority pursuant to subsection 5, the person shall be employed on such terms and conditions as may be approved by the authority, being terms and conditions that are no less favorable than those enjoyed by that person in that person's office under the former entity immediately before the appointed day. 7, a person in the public service who is transferred on secondment pursuant to subsection 5 may be deployed in the public service on or before the expiration of the period referred to in subsection 5 on terms and conditions that are no less favorable than those enjoyed by the person in the person's office under the former entity immediately before the appointed day. 8, all persons who immediately before the appointed day held offices under the former entity under a contractual arrangement shall from that date be deemed to continue to hold under the authority the like or similar offices on the same or no less favorable terms as they held those like or similar offices under the former entity. 9, a person who has served in an office under the former entity and who would have, but for this Act, been eligible to receive a pension thereunder shall be paid a pension where such service together with the person's service under this Act amount in the aggregate to not less than 7 years. 10, the authority may, where it is satisfied that it is equitable to do so, make regulations to be given retrospective effect for the purpose of conferring a benefit or removing a disability attaching to any person who may have been entitled to a pension in the circumstances provided for in subsection 9. 11. In subsections 5 to 9, the former entity means the Firearms Licensing Authority established under the repealed Act. 12. The minister may by
Hold
order...
on. So if a person
Sorry?
removing a disability attaching to the person, meaning if you didn't serve the 7 years, for example, what the disability refers to there? Conferring a benefit or removing a disability. 8410.
I think it might have... Well, it would mean anything that might have prevented the receipt of the pension in the circumstances
Including if you
provided.
didn't serve enough time, because it's removing a disability. I don't know if that is what is intended, but...
No, it doesn't do that.
Huh?
It doesn't do that. Because it says the person would have been entitled to a pension. So it's conferring a benefit or removing a disability attaching to any person who may have been entitled to a pension. So you would already have to have your pension vest and be entitled to it, but yet still be, in the circumstances where there's a disability or there's a benefit to be conferred on you. So it wouldn't affect those, as I read it, who would not yet have reached the time
Look at it in
period.
conjunction with 9.
With 9? The question: what amount of time must pass before one is eligible for a pension currently?
10 years.
10 years. So in 9, the
And
person
it's been
who
brought down to 7 now? Move from 10 to 7? But isn't that what 9 says?
No, because 9 says you would have been eligible
No.
to receive a pension, so you would have already done 10 years.
Amounting in the aggregate to not less than 7.
I'm not understanding that yet.
I'm not understanding it
yeah.
either.
Because there would have been 10 in the
And
in
then
the
you're
current
going to
regime.
bring it, right, if it's 10, you're bringing it down to 7, and then you can still pass the act and bring it down to less than that? Who is that intended to address? Doesn't seem right. I don't know if...
Minister, I'll confirm whether or not the Pensions Act passed in 2018 would have reduced it from 10 years to 7 years, and that's what we're reflecting in the provision now. But I'll check and confirm with you.
The Minister may, by order subject to affirmative resolution of the House of Representatives, increase any period specified in subsection 2.
To say why it's kind of egregious, is that so many things, so many issues, if you're going to reach back to smooth off, can't be a one-sided reach back to smooth out because there are too many issues. So what is fair, but going to create a special case. I mean, it's a policy that would have to be looked at. Yes.
(114) Savings. Notwithstanding the repeal of the Repealed Act, A, the regulations made under the Repeal Act in force immediately before the repeal of that act shall, insofar as they are not inconsistent with this act, remain in force and effect as if made under this act, and may be amended or revoked accordingly. And B, a reference in any enactment to specific provisions of the Repeal Act shall be construed as a reference to the equivalent provisions of this act. 115.
I meant to raise this point as you finished 113. Is there any, what's the rationale for the time period in 113 to A, C, D of 3 years? The holder of firearm authorization granted under these categories shall, in respect of any firearm which on the appointed day is in the possession of the holder of the authorization, other than the import permit, deliver to be marked no later than 3 years. And again in C and again in D. Why do we give 3 years for them to deliver it for marking? In that time, there's no marking, and so we don't have the level of traceability that we should.
So, member, recall that there's a time frame that is set out for the institute to acquire, both the institute and the authority to acquire the requisite equipment for the marking. And also, if we just look back, I think that time had been revised down, but it's to enable enough. It was revised down to a year, wasn't it? Yes, I think this came.
Yeah, the
yes.
point is.
But let's just double check, because I do recall that we had revised. Chairman, from a policy perspective, time was required to enable the transition over to the system, the acquisition of the equipment, and we were told that some had already been acquired.
Yeah.
But I think the time was revised.
It's the sheer volume, I think. That was the bigger problem. The fair number of arms to be marked, and it needs some time to mark them all. Right? So
I think it was revised down from 5 to 3.
Yeah.
So
Can I ask a question as a matter? I don't know if it's policy or legislation, but you're anticipating equipment that is able to do this. Why are we doing it? Why are we sort of trying to guess at the time period after the appointed day? Why wouldn't, because things can happen. Government procurement is not always on point. Why wouldn't we do it by saying on the day that who is it who would give the notice? Whatever time that the minister gives notice that it's now time to deliver weapons for marking, why wouldn't we give the minister that?
It's a sheer volume, you know. Once the law comes to being, they give them some time to do it. So it's more practical, my understanding. It initially 5 years, it went down to 3 years in the discussion here. That's what they're proposing initially. No, we are down to 3 because of the...
Yeah, Minister, but what I'm saying is why give any time period at all? Why not leave it to the discretion of the minister to publish by notice the time at which all firearm license holders under the Repeal Act must now come in, and then it is a year or whatever time from that date. In other words, you're guessing at, it seems to me, the 3 years, 5 years, 1 year, and hoping that that is sufficient time for the matters to be in place to be able to receive them. And I'm saying rather than guess, give it some surety, because if the minister gives a notice, he's only going to give that notice when he knows that the things are landing, and therefore that 1 year from his notice would be far surer. It also means that anybody who might be running away from marking has less time to figure out how to do that.
Remember, all firearms have to be relicensed, and they're annually, and the process is to get these firearms marked within the time period. So they already have a mark, and they have the manufacturer's serial number. What you're putting on now is the national serial number and all the plates. So it takes a little while, and it was thought that the 3 year period would be appropriate, but I'll be advancing it. It's the practical side of it. Mr. Richards?
I don't know if the technical team finds any merit in that.
Chairman, Chairman, through you, just to address the concern that you have in relation to the timeline being set. So initially, the consideration is 3 years would have been an appropriate time within which, one, for the Institute as well as for the authority to would have had the requisite equipment in place to conduct the marking. And then that would have been sufficient time for all firearms to be marked. We recognize that there are a lot of firearms out there in terms of licensed firearms. To note also that the minister has the power under subsection 12 to amend the timeline if it is that we are approaching 3 years and we recognize that the sufficient equipment have not been received by the authority or by the Institute, and it's necessary to extend the time. The minister has the authority there to extend that timeline. It says on page 84, so that is clause 113, subsection 12.
And just to add to that as well, Senator, we would have taken into consideration the capacity of both the authority as well as the Institute in respect of not just the availability of the equipment, but also the number of firearms that are supposed to be marked. The Institute will be marking all state-owned weapons. So consider every single weapon that's within the possession of the JCF, the JDF, the Customs Agency, and having the ability to mark within that period.
You're saying then that stretch is really about processing more so than procurement of the ability to process.
That is correct, because we have already started the procurement of the requisite machines.
Okay, thank you so much.
Chair, the Solgen, who is watching remotely wanted me to clarify the issue in respect of the pension, that the reference, there was a question about why it moved from 10 years to 7, that 10 years is only relevant to public sector staff, whereas the stat body would not fall under that category, and that it is more customary for 7 years to be given. It's given to commissions of parliament and other stat bodies. That is what is customary, and therefore, like the data protection commissioner, she was pointing out. She wanted me to point that out.
Thank you.
Well, the issue would come from another perspective of concern, because what the provisions will do is to make it more favorable, enabling a more favorable consideration for pension to be granted where they fall short. And the question arises as to whether you would want to do that in this case. I mean, where it's appropriate is appropriate, but, you know, there are problems with the FLA, and you don't want to make provisions that seem to
the problem in it is part of the solution is this, you know, in that FLA people are subject to much higher vetting in recent times.
Well, Chairman, I'd just say we just don't want to make sure we're not running ourselves into a problem with these provisions, just to have it revisited. But we can talk about it afterwards without saying too much more. Have we read 114 yet? So remind me, Ms. Grant, this is provided for almost standardly transition provisions where the regs would remain in force until?
Yes, where there is
right.
a policy intention to preserve regs.
So,
yes.
So, Minister, we wouldn't want to have regulations under the old law carrying over in perpetuity, so that outside we're going to provide for it in the transition period, and we're going to hold on. No, regulations can be carried over where it's specifically provided for under a repealed act, and they can apply to the extent that they're not inconsistent. Okay, just to say that we would want any of the regulations being carried over to be provided for under this act. We don't want to be going forward with a new act and have the same old set of arrangements. So it means two things, is that we're going to narrow it down, or if not, we're going to make sure that whatever is going to come over is going to come over properly under this law, and it's not going to operate under the old law.
Rest assured, Minister, we've already started our consultation with respect to regulations. And
I just don't want after 2 years, then when 23 months, that's when it's launched in the CP.
We will not run
My expectations are different in respect of this bill and the team. But
Minister,
just to say, it
can
needs
I understand
to be very
what you're
clear.
asking? You're saying that we are providing here for all regulations under the current act to come over to this one, yes? And are you then, is there concern that they must comply with this, that they must be responsive to this? I'm not understanding.
The provision says that, notwithstanding the repeal of the repealed act, that's the 1967 act, the regulations made under that old act, the repealed act, in force immediately before the repeal of the act, shall, insofar as they are not inconsistent with this act, remain in force and effect as if made under this act, and may be amended and revoked accordingly. And a reference in any enactment to specific provisions of the repealed act shall be construed as a reference to the equivalent act. We have currently, where laws have been repealed and the regulations under the repeal law continue 5, 10, 15, 20, 25 years. What I'm saying is that for any of the regulations under the 67 Act that we intend to keep, they must come over as regulations under this 2022 Act. Because after the little transition period is over, I don't want that untidiness in our legislative process going forward. So the substance, once you decide to keep them, just bring them in properly and we enact them.
There have been new regulations, right?
We promulgate them as regs under the new law, not just a carrying over to facilitate a temporary situation becoming permanent.
No, what you're saying, the new regulations should carry the regulation that from the old regulations they're carrying over.
Whatever old regulations that you will use as remaining relevant, we want to, as soon as possible, promulgate them under this old law instead of continue to use them through this transitional arrangement under the old law.
There will be regulations for the new law.
Yes, so that
so you want them incorporated in that then?
Yes. We want the regs to be the regs under this act and the old ones not be used for any period that is longer than to enable transition.
Well,
yes.
The time enabled to bring the new regulation, which should be pretty short. I expect them to be here later this year.
From my vantage point, if we are utilizing them, meaning that they are not inconsistent and the decision is taken that they remain relevant, then the work is not so great because it's not that you are revisiting and providing regs anew. So that work is far easier to just put them under the new law, in addition to anything else to come. But at least, even without anything new, as soon as possible is to bring them under this act instead of having them operate as carrying over from the repealed act. But we will deal with that internally. I'm just signaling to CTD Richards and the rest of the team. All right.
Uh, 115, Act not to affect mutual assistance. Nothing in this act shall be construed to affect the provision of assistance under the Mutual Assistance Criminal Matters Act. 116.
To affect it adversely or affect it all?
Affect it at all.
Okay.
116.
But it will
Amendment of other enactments. The enactments specified in the first column of the 7th schedule are amended in the manner specified with respect thereto in the second column of that schedule. First schedule?
Yes, we'll just go through. We have gone through many of the schedules.
We had read 2 to 5 already.
Right, so let's go quickly.
First schedule, offenses in relation to which possession of a firearm constitutes an offense under Section 14.3. 1. Any offense under Section 10 of the Child Care and Protection Act. 2. Any offense under the Criminal Justice Suppression of Criminal Organizations Act. 3. Any offense under Section 3, 5, 6, 7, 7A, 7B, or 8A of the Dangerous Drugs Act. 4. Any offense under Sections 5, 6, 7, 13, 17, 18, 19, 20, 38, 39, 40, 41, or 42, 2, 3, or 4 of the Larceny Act. 5. Any offense under Section 5, 7, 8, 10, 11, or 12 of the Law Reform Fraudulent Transactions Special Provisions Act. 6. Any offense under Section 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, 26, 27, 28, 29, or 36 of the Malicious Injuries to Property Act. 7. Any offense again under Section 23, 22, 23, 24, 31, 36, 43, or 69 of the Offenses Against the Person Act. 8. Any offense under Section 45 of the Road Traffic Act. 9. Any offense under Section 3, 4, 5, 13, 15, 17, 19A, 20, or 21 of the Sexual Offenses Act. 10. Any offense under Section 7, 8, 9, 10, or 11 of the Terrorism Prevention Act. 11. Any offense under Section 4 or 15 of the Trafficking in Persons Prevention, Suppression, and Punishment Act. 12. Any offense under the Treason Felony Act. 13. Aiding or abetting the commission of any offense specified in any of the above items and attempting to commit any such offense other than offense against Section 9 of the Malicious Injuries to Property Act.
Madam CPC and the team, I'm going to ask that we do the same indication as we have done in other provisions of the law, just to indicate in parenthesis what the sections deal with. So at a quick glance, those who are using the law will know. Because otherwise, it's going to require go picking up the Dangerous Drug Act. Just quick referencing to improve the reader friendliness of it. I know time didn't quite permit, but we will do that when we're coming back to report from committee to the House for it to be included. They are coming. One moment, Chairman. All right, so we did the second schedule previously. Oh. Which is the next one, Madam CPC? I know we are done.
2 to 5, so the next would be the 6. Yes.
All right, so we go to Schedule 6.
Penalties for certain offenses under the Act. An offense under Section 32, failure to deliver firearm to be marked, etc. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years.
Are the penalty provisions for the offenses?
And that's because these now are breaches of the regulation.
No,
example.
the law, the substantive law.
Yeah, well, these are substantive law, but this is failure to deliver the firearm for marking, which we're giving them 3 years. But if they're a licensed firearm holder, why do you want to give him this level of penalty? If the licensed firearm holder, there are two people who mark firearm. There's the person who imports the firearm. That automatically goes to the firearm, the authority to be marked. But a person who is now have a licensed firearm is required to bring in his firearm to be marked by the FLA on the new regulation, because you know, the registry, he now has to get his firearm in the national registry. It already has a serial number, which we use to trace it. It has a ballistic signature because it's a licensed firearm. So in fact, we know the firearm is under the regulation. Why would I give him such a severe penalty if he fails to come in the 3-year period?
My recollection of the policy behind this is that the marking was so critical to the database and to traceability and holding to account that anyone who has a licensed firearm and doesn't turn it over must not be viewed lightly at all. So we would revise some of the other things, but this one is really to let all firearm holders understand that we need the ballistic signature and we need markings of the firearm so that we can trace it.
Yeah, we have the ballistic signature, you have a serial number, and the ballistic signature.
But they still have to turn it in.
No, that we have. So tell me, what you're bringing it in for? Remember
But remember, Chairman, it's not
traceability. Follow me in. Firearms can be traced once they are registered because they have a serial number and a ballistic signature at the FLA. We are now creating a national registry, which we are adding a local serial number then. That's what we're doing. So he has to bring in the firearm during the time period we have just indicated. We're discussing the 3-year period. You see, during that time, if he fails to bring it in before that time, that's when you're criminalizing it. I'm saying that sounds a bit harsh because we have the firearm serial number, we have the ballistics, and we know the firearm was brought in legally, and he has a license. So what else do you know what we're doing is registering the firearm in the Jamaica National Registry. That's what we're doing with this process.
Minister, bear in mind this is not exceeding though, it's not as if it's a 5-year. It's a 5-year.
I mean, this is what I saw.
Not exceeding.
The
So
same with the number of the modifier, but I do think once we have settled the issue of the prohibited weapons, this is a...
Look at 32 says, the holder of a firearm authorization authorizing the holder to import a firearm into Jamaica shall, upon importing the firearm, or manufacturer of firearm shall, upon manufacturing the firearm, cause the firearm to be delivered to the authority for the affixation of the appropriate mark and for the recording of the information relating to the firearm pursuant to Section 29. And at Section 29, it would be for the country of manufacture, the name of the manufacturer, the date, serial number, type, make, etc. So you don't really want this particular provision to be treated lightly at all.
No.
and also to point out as well, Minister, there might be persons...
Among other things, yes.
Right. There might be persons who might have firearms and they have not brought it in for it to be marked. And I think that's also a risk in terms of traceability, as Minister would have pointed out.
When the firearm is imported, it has to go to the FLA first. Is that breach? It didn't go there first. I let it be, just a bit. I'm still a little bit here because my understanding is that
one of those that we had thought of reconsidering because this was so critical to everything else, but other matters would have been turned over.
Manufacturer, I can see if you manufacture and don't bring it in, you lose him license. Because it'll be a legal firearm, he's going into prohibited firearm. Right. Well, they're supposed to go to the FLA first, you got to get permission. All right.
Right, all right.
33.2, trafficking in firearms or ammunition. On conviction before a circuit court, to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. 33.3, possession with intent to traffic in firearm or ammunition. On conviction before a circuit court, to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. 34, importing a firearm that does not bear the required mark. 1, on summary conviction before a parish court to a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 2, on conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years. 35.2.
It's an offense for anyone who imports a firearm that does not bear the required marks under 29(1) and 2. And 29 relates to manufacturer, serial number, make, model, caliber, or the alternative marking. I think we may have to look back at how this is provided. So notwithstanding one, firearm imported may, under this act, may maintain an alternative unique mark permitting ready identification of the country where it was. The firearm may maintain it. The firearm imported may maintain an alternative
my interest here is
mark.
The importation, he would have to get permission to import it. And that permission comes with the details for authorization of the firearm. How does he get a firearm imported, the illegal firearm will be covered under the first section up to section 19, the trafficking, etc. I'm a little bit worried how this is structured. Minister, I know the mischief is a little bit worrying. Ms. White, there, Mr. Bailey. This is referring on what basis, how does this offense come about? Because the person importing a firearm has to get the detail of the firearm to the police, who checks it, recommends it because he's a licensed firearm dealer, and then I authorize, No, I know, but I'm saying, how does he get to import it without the required mark?
So once you get it in, you go through the process
to
get the license.
To that then. I'm saying this is to import without the mark. He has to report all the details to the police before, and then the police recommend it.
I think how it is worded, yes.
And then, so how does he
Look
get
at
to
the
import
wording of it.
a legal firearm?
I was asking, so you have standard and then you have an alternative set of markings, but I think it is how it is provided for. You want to answer?
No, I'm getting ready. This is before now. This says importing a firearm that does not bear the required mark. So how did he get permission to bring it in? And if he gets permission to bring it in,
Chairman, the way I see this provision operating, as you have indicated, he would have received authorization to import a specific set or amount or number of firearms, and he would have provided the details of it.
Right.
But the fact remains that he could have done something untoward and would have...
Yeah, but in that case, investigate and charge with trafficking, in other words. Yeah, sure. Ms. Allen.
Okay, thank you so much, Chair and members. All right, so it could be a manufacturer's error. So, for example, if you were given a set number of serial numbers for the weapons, and say, for example, one of the weapon, there was just one error in a digit or something, and that came in now, and that the authority would not have that particular number. That is how this particular offense or breach would come into play. So it could be just like manufacturer's error.
That's what my understanding. So I'm saying if he does that, he's not really, there's nothing criminal about it, because when the firearms are brought in, they have to be checked again. They should be checked by the FLA. And if they find this in the thing, they basically seize that firearm. Another part of that day, because he cannot be, he gets a box, as we found at the airport, of 40 firearms, and one has the wrong number because it was changed without his knowledge. That shouldn't be a criminal act. But that's how that importation will come. He has permission to import. He has a serial number. 35 of them are solid, but in the process, the manufacturer or the distributor changed 5 of the firearms without informing the FLA.
Minister, just to point out, if it is that the individual is not aware of that change,
right,
the extent of his culpability is minimal there, because he wouldn't have intentionally committed an offense, and I don't believe this provision as drafted is intended to be a strict liability offense.
My concern with the language is a little different. So under 29(1), the person who a firearm imported into Jamaica, exported from Jamaica, transshipped or transited or transshipped through Jamaica or manufactured in Jamaica shall bear a mark identifying in respect of that firearm a number of things. Hold on, Chairman. So it shall bear that mark. And notwithstanding those marks, the firearm imported into Jamaica under this Act may maintain an alternative, unique mark permitting ready identification of the country where the firearm was manufactured and the serial number, make and model of the firearm. All right, so the duty is placed on whom to maintain that. That's what I was just seeking a little clarity on. So we know the duty on the importer, the transitor, the transshipper, the manufacturer. that once you're bringing it in, these are certain things
Yeah,
that
but
you
that's
have to
another offense
ensure
in itself.
exist. But where they don't exist, my understanding was that the authority or the institute, as the case may be, may permit an alternative to all of that.
No, but that you have gone a step ahead of me, you know.
Oh.
I've not got there yet. But the charge here is importing a firearm that does not bear the mark.
Yes.
How can he, if he brings it in, these are all the requirements you have here, as well as when it gets in, you can put in a mark on it.
It's
the
the
local
wrong
mark.
kind of offense.
But before it gets here now, when they open the box, you're going to see 5 firearms with the wrong serial number. That is what is criminalized here. In other words, you are the importer now. You have brought in, you have license to bring in.
That's not what should be in criminal.
That's what I'm saying, because that's what the same person have here. In other words, he's given a license to bring in. In getting the license, he has to submit the serial number. The police commissioner approves it, and I verify that. And when the firearm is brought in, all those serial numbers must correspond. If one disagrees, then this should appear to be a criminal act. And I need to hear from the...
Minister, as drafted, it would not criminalize a situation where the serial number is incorrect. It criminalizes a situation where there isn't a mark, a serial number at all. Because what is required under 29 subsection 1 is that upon importation, the firearm must bear those marks.
Yes.
But
And
if
then
it's
there's marks referred in 29, which is there's a full marking referred to, then there's still a special number in 2, and then the institute now puts on the special number. But up to 2 is where we are. You can't bring it. Say he'd be bringing in somebody, you say, without any serial number at all. That's when you charge him.
Yes.
Yes, Minister.
All right. That's be clear, because
So I think maybe the provision could benefit from the intentional importation without the marks, because I would say maybe the provision could benefit from the inclusion of the intent. So if it's
No. The minister is saying that you go through a process to get an import license. You have to specify what it is that you're importing. When it comes, it's checked against the inventory and the stock. If something happens to come in that does not correspond, it may or may not be the fault, for want of a better word, of the person who has come in. This section is not intended to operate where an error comes in from the manufacturer or whomever they have sourced the firearm from. If there's an error, that is not what this section is intended to do.
Those found,
but
the
other issue that the minister is saying is that if you go through the process to get an import license, a transshipment license, a transiting license, I don't know, do you, well, this one speaks to importing.
import, export, transit,
Right.
and transship.
If what comes in does not accord with the invoice, and it is through, right, right. I mean, what exactly are you targeting? I'm having a little difficulty with how it's worded or the instructions around that provision. So the duty is to make sure that all firearms that come into the island bear certain basic information for traceability. Those information are usually put on by the manufacturers of it. All right? And when you must bring it in, you're not permitted to go and source firearm from persons who have not standardized the markings on the firearm in keeping with the treaty obligation, because I think this refers to that part of the treaty. So if it is, so you wouldn't, I don't know how it works administratively if someone is applying for the import or who has received an import authorization. Are you not required to itemize what exactly you will be importing? I'm going to import a Mercedes-Benz, a BMW with chassis number XYZ, etc. And then you come and you cross-check what has come in against what you say you're going to do. So outside of that, what is this provision targeting? Because I'm not so clear. I know what we want to do, but I'm not clear when you look on how it is worded.
Getting a bit of overlap with the first part up to the prohibited weapons, where if you import prohibited weapons, they are subject to life imprisonment, literally. This is the regulated firearm, and I think there needs to be clarity here, because the most you do, in practical terms, if you find an importer bringing in firearms which are not properly marked regularly.
But it's a reference to the authorization that is causing some problem, and the process through which you would be authorized to bring
Minister allows the practical, it comes in, if they bring in 2 or 3 firearms in one batch, fine, they're taken out, they have to be retained. If this happens regularly, then what would happen is not so much this, you'd have to go now to investigate individual dealer if he is into something, some kind of chicanery, and he's charged with criminal, he's be subject to a criminal charge. If you find an importer regularly bringing firearms that are not properly marked, then he'll be subject to criminal investigation. I'm just a little bit, like I said, short. Yeah. Yeah, look at it. Yeah.
Through you, Chairman, Ms. Mullings want to come?
Yeah, she's coming.
Good afternoon, everyone. So let me see if I can try and explain what operates currently as it relates to when a dealer is making importing the firearms, right? So they would come to the FLA, they would submit an invoice not with the amount of firearms and ammunition that they intend to purchase.
Right.
So at that point, they would not have the listing of serial numbers. We know, in terms of the authority, we would give them that import permit, and then they would take it to the Ministry, Customs, and Trade Board. It is up on when the firearms are coming in. At that point now, the supplier would give the dealer a list of the firearms with the details of the numbers for each firearm, the serial numbers.
Right.
So when it comes in, Customs does the check, and then when it comes to the FLA, we do the check there. So just as Minister was explaining, it's up on that check. So for example, if they ordered like 10 Glock pistols, they would come in a sequential order in terms of the serial numbers. So if we recognize that there's a serial number that is, that something is off, it's at that point now, we would seize that weapon.
Right.
So I don't think it would be fair to criminalize that person because it would be the manufacturer's error. So I'm not sure if that would have provided some clarity.
That's why I wanted to be clear on this, is exactly where do you charge him?
Well, the offense is a person commits an offense if that person imports a firearm that does not bear the marks required under 29(1) or 2. So, but 29(2), right, is what would come where? Who maintains it? I'm really a little unclear around the instructions. I know the obligation to ensure that firearms have certain markings that include what we have there, the type of it. It's a record.
See.
And then if they don't all have it, what you want is enough that enable you to identify it. That's the alternative marking. Country, where it was manufactured, a serial number, make and model. All right. So what we have to be clear is what duty is placed on whom to ensure that the listed information is there.
See.
So the manufacturer is required to put certain things that you manufacture on the firearm. If you manufacture it here, since we have it, that's what you have to put. What if the manufacturer is outside of the island? What control do we have over such manufacturer to ensure that that is? And telling me that it is standard doesn't answer the question.
So, Minister,
I'm a little bit further disturbed,
Yes.
And I'll ask for comments again for it, because, you see, it's not just once you bring in the firearm without the proper markings, you can seize it. We have to inspect it, all right? So you couldn't charge them at that point. The manufacturers or even distributors change. Now, in terms of the act itself, if somebody gets a license, now we'll stop giving them a license individually, but I suspect if that was authority. If a person got a license to bring in a firearm and it doesn't have the marking, an individual, or he brings it in, it would come under trafficking and prohibited, whether the prohibited weapon or in, well, dealing with a prohibited weapon. That's an illegal weapon. Then the penalty would have to be the higher penalty. That's why I'm a little bit off it, because if the importer brings in a weapon without the markings, how do you seizing it? But if he brings, it would have been a legal weapon that we are looking at now. We couldn't charge him 5 years. It's a wording of it. Have me a little bit off. I need a little clarification to be sure, because what I don't want to do is to criminalize the man who gets a firearm in his within license that did not relate to the invoice, as you have indicated. So technically, he's importing an unmarked firearm, but it was not by his doing. So I need laws to be trained. But if another person brings in a firearm without the permit, but that will be covered elsewhere, and he should be subject to the 15-year penalty. So I find this piece here a little bit, Minister, I find that a little bit ambiguous. It's kind of falling between neither hot nor cold, neither for the authorized nor for the unauthorized.
PC wants to win.
Well, I was just wondering who it was targeted at. Is it the person who is sending the firearms to Jamaica? In that case, the person who imports it would not be the appropriate term. It would be the person who sent it to Jamaica.
Yeah,
and what would be the proper recourse against the person sending? So on the international side.
Yeah, but there's some international, there's a clause covering international conduct somewhere else. Mr. Richards, you're saying?
So, Minister, I just wanted the opportunity to sit back again with the team, including the technical team from the FLA, because in my mind I didn't see anything wrong with the provision. So hearing the concerns now, and was asking to sit back with the technical team to review what is here.
Okay, yeah.
And then we'll come back with
I kind of find it not sure where it's going, whether it's against the illegal farm or the importer. What I don't want is to criminalize the importer, who is a legitimate businessman for years. Most of them are long-standing people, just by an error from his supplier. All right, take a look at this.
Provide for an offense that someone commits an offense for something that he has no control over.
Yeah.
And I think that's the challenge here.
Yeah.
With the way it is. I understand the requirements for the marking, and I understand, but other things are unclear.
Okay, I don't know the penalties for the section, because what I'm looking at, the way the bill is structured, section 1 to 19 covers the prohibited weapons. So if a man brings a prohibited weapon, he's going to be subject to life imprisonment. They don't need to, my understanding that doesn't need to be covered here again, because that's inserted in the clauses relating to those activities by the illegal prohibited weapon operator. Now, this, therefore, is dealing with the legal importer. So, I'll leave the team to look at it again, please. Yeah.
So we will look back at both 29 and 32.
34 really is the bugbear.
Well, all of the provisions relating to the markings. The duty to turn in the firearm for marking is clear, and we know what the marking should be, but the other matters are not so clear.
Continue, 35. Oh, well, it's 2:15. I don't think I can finish Schedule 6 before lunch. It's going to be tough. Well, said 2 o'clock. Well, it shouldn't be that. Yeah, it's a little bit, this is a long penalty section.
Long schedule.
Yeah.
Miss Wilkins, you gave up your right to complain,
Yeah. We can do this. We can do this.
Point taken. Point taken. We probably could take the break. And in between, we just ask that you just check the entire schedule against the offense-creating
we
provision.
can take care and do this on virtual tomorrow.
Yes.
It's pretty straightforward, right?
Yes.
All right, so we can do Thursday.
So we will take the break now?
We adjourn because we're taking lunch. It's 3 o'clock.
All right, Chairman, just permit me
Yeah.
to remind all persons here who must submit declarations to the Integrity Commission, if you have not already done so, to make sure that you
Tomorrow.
do so on time.
Be done tomorrow.
And if you still have outstanding documents, just submit and then provide them later. But try to meet the
Minute.
timeline, please.
Minister, you have submitted yours already?
I'm a member of the Oversight Committee of the Parliament on that matter, Chairman.
Mine will go in tomorrow.
Me too.
No, but it's a personal.
So we move for the adjournment of the committee.
Yes.
For resumption tomorrow virtually?
Tomorrow
or
virtually.
hybrid?
We complete the schedule, I would think.
Hybrid or we come
Tomorrow
back
we can
here
do tomorrow virtual tomorrow.
Virtually or we come back here?
No, I do the virtual tomorrow.
Virtually.
Because it's pretty straightforward. Yeah. Thursday. Thursday will be hybrid.
Yes.
So we're going to
Right.
invite some of these people in.
Tomorrow I suggest, Minister, that we complete the bill.
Yeah.
And I
So we
think
can do it virtually.
Thursday, and then we can take some time
Take
to
up
do
of the
some
people on Thursday and nothing Friday.
tidying up. Sorry?
We do nothing on Friday.
Right. So, but tomorrow is not a lot we have to go. So what else are we going to do with the time tomorrow, unless we're going to give Ms. McCarthy the time to put the minutes of the various meetings
What have
together?
we got to go tomorrow? We have the rest of the schedule. We have the 6th schedule to complete. We have then we go right through to the memorandum, right? It will take, given the nature of this bill, we're going to take the time. If we get a few hours, Mr.
So we
McCarthy.
resume virtually tomorrow,
Yeah.
entirely virtually,
Yeah,
not
we have to
hybrid.
standard, yeah.
All right.
Tomorrow is Wednesday, 10 o'clock we start.
All right.
And Thursday we do 11 o'clock and have 2 of the,
And Thursday we're coming back in person,
well, hybrid.
hybrid.
And
All
we'll
right.
invite in 2 of the, where do this have? Let's read out
But the
this.
core team of CPC, law reform, MNS.
Myself and yourself. Minister, you can't escape me, you know.
No, we're joined on the hips for this one. But
I have some more. We have a number of submissions. You have looked at them, Minister. I think we could take for Thursday. We could do all of them. They don't look that long. No. When I say all of them, the Rifle
ask
Association, Custom and Defense.
members
That's all
to
taken.
start going through the
Those three.
matrix, please.
Yeah, Custom not long either. Really. Not much. All right. They have to come. That's why we're doing it hybrid. Minister, looking at this submission, we just need to take GRA, Customs and Defense. So we start with, you want to start with Defense?
We can take, let's do as many as we can. We can start with
Start
defense
with those and take a
right,
look at
so
it.
at
No,
least 5
most
of
of the
them,
others
if
are-
we have as many to take. All right? And then we get over, because the greatest part of the work is going to go through now
Because-
that we have familiarized ourselves. We still have a lot of work ahead of us.
We have 14 submissions, but many of them are repeating, which was to do with a misunderstanding. 90% of them are that way, but the Rifle Association has some suggestion, Customs have some concern, and JDF, those are genuine concerns. You may want to, I'll allow you to look at the Bar Association from Cornwall Bar, since the Bar Association did not make a submission, Cornwall had some submissions we could look at, and I think that Mr. Champagne have made some other suggestion we want to wish to look at. But we could start with Jerry and JDF Thursday. Oh, yeah, all right. Give them an hour, half an hour and an hour. All right. Let me thank everyone and for your resilience in delaying lunch until 2 o'clock. As a
You're
physician,
saying the DPM is providing lunch?
lunch has been ordered by those for lunch, yeah. And the technical team, the ministry has agreed to continue to bear that cost. It's yours. All right. But I think we have done well in coming to this far. I have to commend the teams. We have been working 3 days a week. And Ms. Grant has been reading and reading. this then really supposed to give you a PhD that is granted. So it's reading for another advance. But let me thank everyone. We'll just continue with what you're doing. We hope we should be able to give you this month of April to put all the amendments, etc., together. Most of April.
Be reminded, DPM, we have other joint selects to come.
Yeah.
We have a whole lot to come.
We'll lock off the days again. I'm
we have
locking
the
up.
Integrity Commission and the disclosure. That's right.
Which
on
is
the
why
heels of this.
the days in April have been locked by these committees. So I'm going to lock off the May dates, the first 2 weeks
and
of
we
May.
have some others to complete, but
We're finishing this one.
Yes.
Right. And I have another bill to bring, you know. I have and it's not a short bill. IRCC aliens.
We have many more to come. It's going to show just
This
how
one tells me
inadequate the facilities of the
we
Parliament
might
are.
be able to avoid the joint select and the IRCC aliens. So it's been around a little while. I thank you. We adjourn until tomorrow at 10 virtually. All right? Miss, you will send out a link for us. Yes. All right? Thank you. Have a good afternoon. The Prime Minister now on his way to Washington, members. So, Minister and members, I'll take charge of your time.
I think persons may have indicated the lunch. I don't know how that's going to go, so it would have been...
If you have, once you have signed
You're
up...
waiting?
Yeah.
Once you have signed up for the lunch, you're required to have the lunch. Minister Main and the others. Senator Golding, that goes for you too.